Yes.
Answering. Origin side listed matters, commercial division, item number 1.
Is it? Well, I appear for the plaintiff. Well, on the last occasion, your lordship had directed both parties to file their suggested issues. So the issues could be framed. Well, ours is ready. May I file yours?
Well, today what I find, it is already ready with us. The soft copy is with us. My lord, please give me a permission so that we can file it by today, course of the day, my lord.
Well, may I suggest this? Well, I'll sharing my copy with my learned friend. Well, the issues. Well,
Making it not today, come tomorrow.
It is a suit for recovery of possession and eviction. Well, that is the only real issue. Whether I am entitled to eviction, entitled to lien profits, whether the defendant is.
My lord, there are we have
I will check
7 issues.
Come tomorrow.
Yes, my lord.
I'm making it not today.
Not today, my lord.
But tomorrow you must file the issue.
Yes, we do have it with us.
Not today.
Well, let the GA application also appear along with it. Well, there is a GA 7.
What is about?
Well, that is for appointment of a commissioner for taking evidence. Your lordship was pleased to observe that this should appear.
Let the issues be fulfilled.
Yes,
first.
immediately after that.
Yes.
My lord.
Grateful.
Commercial division, item number 2.
Where the commissioner will go?
In Calcutta, because my lord, the person who is going to give evidence on behalf of the plaintiff is almost 86 years old and he's suffering from cardiomyopathy. So he's been advised, my lord, not to do too many physical.
My lord, we do not have any objection.
I should not have.
No, that is different. Whether I should not, do not use the word
fair,
should not.
I said.
I take it's very prejudicial.
All right. Come tomorrow.
Item number 2.
I am for the plaintiff in this matter, my lord. My lord, on the previous item number 2, no. My lord, I am appearing for the plaintiff in this matter. On the previous occasion, my lord had directed that the matter, the inventory and the discovery and inspection of the documents be completed. My lord, the process has started, but in the course of discovery and inspection, it has transpired that some of the documents which were to be provided by the plaintiff, my lord, those are in the custody of the city civil court. One document, particularly one document, is in the custody of the city civil court. My lord, we have applied for certified copies, but since it was submitted in 2005, it is taking some time to procure that original copy from the records. My lord, I am only praying that the matter be kept after a fortnight or be placed after the vacation. In the meantime, within a fortnight, we will complete.
My lord, I appear for the defendant, my lord. I have got no objection to that. Yesterday, I, along with my client, went to their solicitor's office to inspect the document. At that point, we are informed that one of the document is not available. My lord, I am not standing in the way. Let it be true.
The learned counsel for the plaintiff prays for time for discovery and inspection of document. Time is allowed. Let the matter appear in the list on 27 December. 7 December.
Much obliged.
Much obliged.
Where is your other side?
Regular list, item number 1.
My lord, this matter, I am for the judgment debtor, my lord, Subhasis Sengupta is appearing as our learned counsel. He is indisposed today. And my learned advocate, senior advocate, Mr. Aditya Gardi is doing Shraddha at his home. Kindly keep it any other day, my lord. Today, kindly. Yesterday, the matter was called on. Your lordship was pleased to fix it on 9th of October 2023.
Always then come on 9th.
My lord.
This letter, with this, I have submitted the report of the special deputy. So, registrar may real, I want to direct it to produce those enclosures in the letter.
This was placed with the
My lord, the special referee report determining the
mean profit.
mean profit in 3 envelopes. I had seen that in the court before which justice Muslim Bhattacharya.
That should be called.
That will be called.
All right.
That is not done. If it is called, then that will be.
The learned counsel for the plaintiff.
For the judgment debtor.
For the defendant, prays for time. Let the matter appear in the list on the date fixed, namely on 9th October. Learned register original site shall produce the report of the special referee on that date.
3 envelopes. 3 sealed envelopes.
That as it may be.
আমাকে proceedings
Let it come for hearing because this officer is pending for 5 years
All right.
for hearing.
Okay.
For final hearing. Lots.
Item number 2,
To my lord, I appear for the petitioner, my lord. On the last occasion, the lordship had been pleased, my lord, to direct the department, my lord, to submit a report with regard to filing of caveat. It's a PLA matter, my lord. So if that report has come, because lordship had, my lord, knows, my lord, as per the report, my lord, I'll have to file an application, my lord, as to who would be the defendants in the case, my lord.
Caveat is there.
I'm sorry.
Caveat is there.
It's there. Lordship had noted on the last occasion. Lordship wanted
the
the
caveat?
department.
Who is
No, like, it should be there in the report, my lord. Lordship had, but to be sure, Lordship had asked for a report, my lord. It's an order dated, my lord, 29th August 2023, my lord.
It was filed on 4/8/2005 by the caveatrix. So you have to file an application now,
I will, my lord.
either
So,
28 or 30.
28, my lord. In this case, 28. Now, my lord, Lordship has, my lord, who's the person who has filed the caveat, my lord?
That is not here.
It's maybe Jharna Devnath.
Jharna Devnath.
Yes.
That's the only caveat. That is all.
You check.
Obliged. Deeply obliged. Thank you. Pending.
What is the
Caveat and affidavit, sir. Obliged, my lord. Deeply obliged. We shall take necessary steps, my lord.
Learned counsel for the executor, please leave to file appropriate application in view of report of the department that one caveat was filed earlier by one Jharna Devnath. Leave is granted. Let the matter appear in the list on 14 December.
Obliged.
I appear for the petitioner number, plaintiff number 2 in this matter. Lordship, they have taken out an application for removal of names of persons who have passed away, both plaintiff number 1 and defendant number 2.
What about 14? 14 is for?
14 ta konta? My lord, GA ta koto ko tomader last meter?
4 and 14. 2 GAs are pending.
My lord,
4 is the perjury.
4 is one perjury application, that is 6. 3 is the GA for which they have filed to remove the names of the persons who had passed away in the matter. Plaintiff and defendant both. Now, regarding this application,
Date of plaintiff number 1, date of defendant number 2.
my
That's
lord,
right,
my
my
lord. Now,
And legal heirs be brought in the record. Who are the legal heirs?
I think
it has not been indicated. There is a defect in this application. I'll indicate. Number 1. Number 2, so far as the plaintiff is concerned, his legal, her legal heirs should be from our side, we should place it before your lordship. Who shall be substituting, not them. And secondary, the amendment has to be carried out in the main suit, not in this application alone, because
Absolutely.
this is an original side matter. So, let it,
I think it should be filed anew.
my lord, I have indicated, my lord, who the legal heirs are, my lord. I don't know why my learned friend is saying I have not indicated. He's not read his
My lord,
brief properly,
so far-
perhaps.
Where
so far
is
as
that? Let me submit.
my lord.
My lord,
Don't make a chaos.
two parties have died, my lord, the plaintiff number 1 and the defendant number 2. So far as the defendant number 2 is concerned, my lord, or rather, so far as the defendant number 1 is concerned, my lord, kindly take paragraph 6 at page 4 of my affidavit.
I say that during the pendency of the aforesaid application, plaintiff number 1, namely Rani Aloka Dudhoria, died on 15th May 2023, leaving behind the plaintiff
So
number
there is
2
no
to
need
8.
for
So
substitution.
there is no need for substitution so far as the plaintiff number 1 is concerned. Kindly take the next paragraph, my lord. I say that the defendant number 2, Gautam Dudhoria, he is also passed away on February 14, and Lee has left behind, my lord, 2 heirs or 2 legal or representatives, Yasmin Dudhoria and Gaurav Dudhoria. They should be brought on record, my lord, is my humble submission. I've indicated their names, I've indicated their address as well.
Don't need to.
Yes, that is mentioned.
My
That's
lord, one thing, my lord, I must indicate, kindly takes, my lord, paragraph 9 at page 5 of their application.
If prayer is that, that may be defective.
My lord, only in the application, my lord, cannot be, my lord. It should be, my lord, carried out in the main suit.
Is that?
My lord, they are
in
praying
there?
for be recorded in the present application. My lord, cost title amendment in, my lord, original site, my lord, it has to be carried out in the main suit.
Absolutely.
Certainly.
Because parties are made in the suit, not in the application.
My lord, I'm grateful. My lord, so far as, my lord, that is defective.
My lord, my application is in the main suit. I don't know again what my learned friend is saying.
So that might be, let that order be passed.
Continuously making one wrong
Not be
submission
carried
after
too
another.
much by these nitty-gritties.
My learned friend wants to delay the matter, I
My lord,
understand.
that is
But let him
not,
at least not make incorrect submissions when his
Have
attempt
you
to delay
filed
the matter.
amended
that's,
plan?
my lord, that is a presumption.
Have you filed amended plan?
I will amend it, my lord, pursuant to your lordship, my lord, allowing my prayers.
Why is it not filed along with this? It is supposed to be filed along with this in the reading. It is supposed to be filed along with this in reading. File supplementary affidavit.
Very well. Or my lord,
And what about this, the other?
My lord, the
GF4?
other one is a, my lord, perjury application. My lord, first of all, my lord, the cost title needs to be amended, my lord, before proceeding with that.
All right,
And my lord, so
let
far
that
as
be
the
done
part-
first.
And my lord, there are other matters, my lord, it is not maintainable anymore in light of Supreme Court judgments already passed in this name.
Let this thing be done first.
My lord,
Learned counsel. Or you are for plaintiff.
for the, no, my lord, I am
I am
for the
plaintiff number
defendant number 3.
You are for
plaintiff 2, my lord, he is for plaintiff 4.
learned counsel for defendant number 2.
3,
3.
my lord.
3 craves leave to file supplementary affidavit incorporating amended plaint, which is missing with in GA 14 of 2023. Leave is granted. Let the same be filed within returnable date. The matter will appear in the list on 11th October.
My lord, so far as my lord, the amended plaint, my lord, because the plaintiff, my lord, needs to, my lord, according to my lord, original side rules 4, my lord, all my lord changes has to be, my lord, verified by the plaintiffs.
Plaintiff, right.
My
Let
lord, that
that
is
be
my
filed.
lord, let that be filed. My lord, so far as my lord, one other, my lord, I'll indicate right now. My lord, plaintiff number 2, my lord, the Vakalatnama, my lord, is on the way because it has been, my lord, sent from USA. My lord, it has been apostilled. It has been consularized. Now, my lord, it is on the way. It will reach us in some, my lord, maybe a week or 2. My lord, we can file that, my lord.
After vacation.
Perhaps it is better, my lord, instead of 11th. In the meantime, let them do the
No
supplementary
difficulty, my lord will keep the matter
1st
any date
December.
after vacation.
after
1st
the-
December.
Very well, man.
Hopefully it will come in the
My
meantime.
lord, it will come. In fact, it has been completed. My lord, I have got soft copy. I have already
All right.
received.
Suit is of 1977.
My lord, my lord, my lord. Suit is actually has been disposed of by the Honorable Supreme Court in 2006.
All right, that I will
My
not
lord,
look at.
that will come, my lord. Yes.
We will see, my lord. My lord is fixing the date.
1st December.
I'm great.
1st December. I'm grateful. Your lord.
3 and 6. My lord, both the G items, 3 and 6 items.
Yes.
Both 3 and 6. Yes, my lord.
Even we need to hear the GA 14 first now.
Yes, yes.
My lord.
Yes.
I'm grateful to you.
I'm grateful.
My lord, I am appearing on behalf of the trustees. I am led by Mr. Surojit Mitra.
Lord, on the last occasion,
Shobhabaja Rajbari.
yes. Lordship remembers, my lord.
I have to.
On the last occasion, your lordship was hearing, my lord, GA4. I'm sorry, GA5. GA5.
GA5 is for
GA5 is one, my.
conveyance. Shodhpur property.
Ah.
Panihati property.
Sodhpur property.
Whatever
Two
it is.
properties which has been sold.
And GA6 is for
My lord, for extension basically of the, my lord, the trustees, the present board of trustees, they are functioning on the basis of a court's order, which was, my lord,
development of Shobha Bazar market.
that is incidental, yes.
That is first prayer. Second prayer is continuation.
Yes. Well, unless continued, my lord, the first prayer possibly will not come.
For a further term of 3 years. When it is about to expire,
It has already
It has
expired
expired, my lord.
for the time being, it's going on.
Yes.
for the time.
Pursuant to court's order, they are going.
What was the last order?
No, last order, your lordship was hearing GA5, my lord.
The last order.
No,
there was-
one that must be, there must be some extension.
Oh, I see. Yes, yes.
My lord, if my lord takes the order dated 2nd of May 2023 passed by my lord. If my lord takes that order.
My lord, kindly come to order of 13th December 2022, my lord. Passed in GA number 6. 13th
Yeah.
December 2022, passed in GA. The last sentence, my lord.
Yes, order dated 26th August 19 shall continue to function till further order. So need not extend.
No, my lord, thereafter the order was passed by my lord on 2nd of May.
Second May the queue.
2nd May, the last portion. The last part of the order. The board of trustees is to function in terms of the order dated 12th September till the next date. No further extension has been.
No, there is some wrong. This order is wrong because it is 23 anyway.
Initially, it was 13th of December 2022. My lord's first order. Till the next, until further orders. The order was modified and it was extended.
Well,
on-
there was no prayer for modification of the order with greatest of respect, my lord. There was possibly a typographical mistake, my lord, and my lord, it
It must be
escaped
so.
our notice also.
Must be so. All right, it will be extended till further order.
Lordship.
Let this be arrangement for the time being. Now, so far as GA, that will take care of your prayer.
No, that has to be, my lord, finally extended.
Yes, no, for the timing that will take
Yes.
care of GA 6 prayer. C to certain extent, B and C to certain extent, if not for 3 years, but to certain extent that will take care of it.
And there was a direction to file an affidavit on behalf of the purchase.
You appeared for Bikram Adhikari. Who appeared? Last day someone appeared for Bikram Adhikari.
Yes, a lady appeared.
Yes.
My lord, affidavit has been served upon me.
You are for?
I am for one of the trustees appointed by this.
Not for Bikram Adhikari.
Not for Bikram Adhikari. I am for the. If my lord takes the affidavit once filed, which has been served to me.
Where is the affidavit?
My lord. Affidavit. No. Affidavit has been, I think, affidavit has not been filed, my lord. It was a.
Affidavit in opposition. Liberty was given to file affidavit in opposition on behalf of Bikram Adhikari. Yes. Have you filed this? Leave was granted to you, can file it now.
An affidavit in opposition has been filed.
That must be against GA number 6.
GA number
GA5.
GA5.
GA5. Would you file any reply? Anyone?
No reply. I have not filed any reply. My lord, no reply is required. If my lord takes annexure C, page 19 once of this affidavit.
Page
19.
Page 19 of
The affidavit filed by my learned friend, my Vikram Adhikari.
what is your contention? First tell me what is your contention in your affidavit, what have you stated?
In my application,
You have filed affidavit in opposition. You have filed affidavit in opposition.
Yes, yes.
Where is that? ওইটা দাও J6 না J5 এর দাও এও
GA5, I have filed affidavit in opposition. My learned friend's client has also filed his reply.
reply is there.
Yes, in fact, my client had also filed a supplementary affidavit, my lord, after the affidavit in opposition.
What is your contention? Lastly, what you submitted that the please their financial crunch at the time of
There was my submissions were there was no financial crunch.
financial, you
I have
pointed
placed
out the statement of accounts.
statement of accounts.
54 lakh or odd something was
54
there.
lakhs and odd was there lying with the accounts. And my first prayer was for to set aside the sale without seeking any permission of this honorable court. How the other three trustees, without seeking any permission, has sold this property at a meager amount. The market value of the property, if my lord takes that my application once, the market value of the property is 48,52,666 is at page 64. And the consideration which they have received is 3 lakhs. And without seeking any permission from this court, how this property is being sold? This is one property, the other one has also been sold to the same person. And if my lord takes the affidavit filed by Vikram Adhikari, if once takes page 19
of
19 of the affidavit which has been filed by Vikram Adhikari.
Yes.
Name of the assessee. It's of the year 2016. 2015-16. Name of the assessee is Tapos Kumar Dotto. And the affidavit which my learned friend has filed is stating that the Tapos Kumar Dotto is the uncle of Vikram Adhikari. I put a question to myself, what is the relation between Tapos Dotto and Vikram Adhikari? That is one thing. And how this is the property.
That I'm sorry to interrupt, my lord. Then he has to file a response to this affidavit.
And how this name is appearing as Tapos Kumar. It's the property of the Rajbari. Estate of, it is the property of the, how the name has been recorded as Tapos Kumar Dotto, Tapos Dotto is the name of the assessee.
So you file a reply.
It's my submission, my lord. And may take on record, my lord may take on record this submission.
All right, I have seen these things. Then
My lord, and the other thing is with regard, I have made another submission with regard to the Pala rights.
yes.
The Pala rights. They are changed, the three trustees have changed their Pala rights on their own whims and perils. Without seeking even any permission from this court, the Pala rights has been modified. If my lord takes the Pala rights,
Page
30, it starts at page 30, annexure C of my application, GA5, annexure C, page 36.
Page 36.
Page 36.
Yes.
It's a notice for modification and accordingly a new Paladar list has, may I place this notice? It's a notice dated 23rd of February 2021. notice. It's addressed to Sandeep Narayan Dev, one of the Sebayats. With reference to the last meeting of the Sebayats of the estate of Raja Sir Radhakanto Dev Bahadur, dated 18th February 2021, which was called by notice dated such and such. In that meeting, under Miss Agenda, it was unanimously decided by the present 18 Sebayats that a new parada list to be prepared and to be circulated amongst the Sebayats for their record. Accordingly, a new parada list has been drafted by the Sebayats presented in the above meeting, which we are attaching with this notice. All the Sebayats are requested to go through this and provide us your valuable opinion to foolproof this list by 15th of March 2021 till 5 p.m. Suggestion / amendment by a Sebayat will be entertained only when a communication
Alright,
is at
next. This, according to you, is a whimsical act.
this was the first pala list. Thereafter, if my lord turns to page 40, Annexure D.
Yes.
This is how the pala transfers from one of the Sebayats to other. This is the family tree. This is Brojo Kumari, number 1. Brojo Kumari is the eldest daughter. Thereafter, Brojendo, the youngest son. Kamal Kumari, the younger daughter. And Surendra is the younger son. This is how the pala used to be followed. And if my lord turns, the family tree is there at the next page.
What is your point in respect of this one?
This one, with regard to the pala list.
Yes. What do you have to say?
The new pala list has been taken on record. If my lord turns to page 45. If this pala list is followed, everyone would get the pala as per the family tree. If the earlier pala list, which has been modified, is being taken on record and is followed, the entire thing gets shuffled up.
No, we are now concerned with first the transfer or the
First the
complaint.
transfer.
Second thing is whether to change this Shebites. So how this is connected to that change of Shebite issues?
Sebayat issues means Sebayat issues the pala list. The Sebayat gets their pala as per this family tree. If the pala gets shuffled up by the three trustees on their own whims, the person who are near and close to the trustees, the three trustees,
Getting preference.
Huh?
Getting preference.
Getting preference.
That is your point.
That is my point.
All right. So these are the grounds why you want to challenge or these
Sir,
want to change
challenge.
the board of
If my
trustees.
lord takes their application GS6,
Let us concern with J5.
J5. This is my submissions. And my submission is the sale should be set aside as I have prayed for, and no further extension, and the new board of trustees should be appointed by election, as it has been stated in the order dated 2019 by Justice Ashish Kumar Chakraborty.
Yes, Mr. Mitro.
Kindly take his application. GA5.
Yes.
Now, well, we always learn that you put your best point first. Now, let us now see, my lord, or let me try to demonstrate what is his points. Now, kindly take the application. Kindly come to paragraph 7, my lord. That is the first allegation at page 11.
Since appointment.
Sorry, my lord.
Since appointment.
Since appointment. Since appointment, the petitioner looked after and supervised all the works of the estate. It was decided between the trustees that the trustees would receive monthly honorarium. The monthly honorarium was fixed at rupees 5,000 for each of the trustees, and the member of the managing committee would get an additional amount of rupees 2,000 each. As such, By a letter dated 23rd October 2019, the petitioner requested the other trustees to grant the honorarium of rupees 7,000 to the petitioner. The said letter was duly received by the office of the trust estate. In spite of such request made by the petitioner till date, the petitioner had not received any honorarium. This is his allegation that he is not receiving the money. Now kindly come to page 35. This is what prompted him. Kindly come to page 35. The letter which he wrote, my lord, on 23rd October. You all are well acquainted that after appointing as trustee of our estate, I am spending on an average 4 hours at estate office from Monday to Saturday to supervise various works of estate. Recently, we had a preliminary discussion with the Babushahi Shomiti members of Shoabajar Market, whatever market, and Hatibagan Market for taking over our portion from them as a landlord. In near future, if we take over the above markets, then our activity will increase for maintaining the markets. As 3 of you are busy with your job at your own professional fields, I have to attend regular meetings at morning time with them for collection of rent and to solve their problems for running the market smoothly. So I will spend whole day for estate work. Considering the above all facts, I am appealing to you for granting me honorarium of rupees 7,000 only for boosting up my energy and motivation to do more estate work. Now this letter does not mention of any decision to pay, my lord, any additional honorarium to anyone. It also does not, my lord, refer to any right. Now, my lord, I have in my affidavit in opposition have said that, my lord, the other trustees, or at least some of them, my lord, never received any honorarium. It's after all the family thing. Family members are managing. Question of, my lord, receiving honorarium, at least, my lord, there is no right. A request was made, that was in 2019. Now that has, my respectful submission, made him make this application, because I shall try to demonstrate before your lordship that, my lord, the other allegations are also, my lord, similarly frivolous. This is the first allegation. Now kindly come to the second allegation. Kindly come to, my lord, next paragraph, paragraph 8. Paragraph 8, my lord, page 11.
New Paladar list.
The petitioner was totally astonished after perusing notice dated 23rd February 2021 addressed to one of the Shebites. Now, he does not say that he perused this list later. So, I presume that he perused the list immediately after the date of this notice. Shandip Narayan Dev, wherein in presence of 18 Shebites on 18th February 2021, it was decided to prepare a new Paladar list. He does not deny that. The decision taken by Shebites to prepare a new Paladar list, my lord, is not denied. It was further decided that the Paladar list would be circulated amongst all the Shebites for their consent. No such notice was ever served upon the petitioner, and all such decisions were taken behind the back of the petitioner, though the petitioner is one of the trustees to the estate appointed by this honorable court. Now kindly come to this document, page 36, my learned friend had relied on. Kindly come to page 36. 23rd February 2021, my lord, this application was made after, my lord, if your lordship is pleased to look into the date, more than a year. Sometimes in August 2022. With reference to the last meeting of Shebites of the estate of Raja Sri Radhakanto Dev Bahadur dated 18th February 2021, which was called video our notice dated 1st February, In the meeting under miscellaneous agenda, it was unanimously decided by the present 18 Shibaites that a new Paladar list to be prepared and to be circulated amongst the Shibaites for their record. Now, this is not under challenge. He has not said that no such meeting was held. Now, when he came across this notice, my lord, he did not write a letter. My lord, normal reaction would be, my lord, with greatest of respect, as soon as, my lord, I come across such a letter, if it is behind my back, I immediately write, what is this? When was the Shibaites meeting held? No. And all the Shibaites have decided to do this, my lord. We as, my lord, trustees have nothing to do.
So your point is it was known to him.
Yes. And that is one. And number two, my lord, it's a decision of the broader board. I mean, all the Shibaites. Amongst the Shibaites, my lord, few are appointed as trustees to manage, my lord, the affairs, the day-to-day affairs. But the trustees, my lord, the Shibaites unanimously decided to, my lord, do this.
So there was notice of a meeting.
Yes.
And whether he has received it or not.
Now, my lord, the difficulty, I will tell you, lordship, the difficulty is a family matter. My lord. Notices, my lord, are, yes, there is a trust office, notices are sent, but nobody maintains, my lord, it properly. Now, he does not say, my lord, when he came across this letter, my lord, normal human behavior would be that he immediately writes a letter, what is this? I did not have any notice of this Shibaites meeting. He also does not say, my lord, in this paragraph 8, he does not say that, my lord, such a meeting was held of the such a meeting of Shibaites was held. And
it is not denied, according
he
to
does
you.
not deny.
And that was not earlier challenge.
Now, my lord, no, Mr. Dev is threatening me from there. I am continuing for long.
Oh, he is here.
Yes. And he is threatening me. Your lordship was reading, my lord. I turned my face to see, my lord, he is threatening me.
In the bar can threaten Mr.
সে তো সবাই জানে।
Serious consequences.
For continuing. লাইব্রেরিতে বসতেই পারবো না তারপর। Yes, Mr. Dart Pilot from behind rightly points out another Deb.
So a constructive notice was made. If no communication is received by 15 March 21.
Yes.
Yes.
So no protest was there.
That is your second point. So far as
that is the second allegation. Well, third allegation is, my lord, the Shukchar property. Now, my lord, kindly come to the allegation. Kindly come to paragraph 14. কি আজকে বলবো নাকি কালকে পরের দিনে বলবো বলো?
Because I have to hear her. After hearing you, I have to hear her.
Oh, then, my lord, should I can
as you like it. I have no problem.
ঠিক আছে.
Subject to confirmation.
Absolutely. My lord, may I continue on, sir? Very
all right, to certain extent. Let there be a middle path to certain extent.
Yes, very well. Now, my lord, their allegation kindly come to paragraph 14.
Hmm.
Page 13. Even a property measuring an area of 4 cutters, 2 chatak, 38 square feet, lying and situated at Mauja Shukchar, jail number, etc., comprising of land measuring 3 cutters, and RS numbers and land measuring 1 cutter, 2 chatak in such and such, along with 300 square feet asbestos roofing, was sold by the other 3 trustees in their individual capacity, without any intimation and or information to the petitioner, one of the trustees appointed by this honorable court. The market value of the said property is rupees 48 lakhs, whereas the property was sold at a meager amount of rupees 3 lakh. The said deed of conveyance was executed on such and such. The petitioner obtained photocopy, which is annexed. This whole sale is wholly illegal, as the same has been sold without seeking any permission from this honorable. Now, my lord, kindly take my affidavit in opposition once. Or before that, my lord, before that, if your lordship is pleased to come to, my lord, his application, my lord, GA5. The first annexure, which starts at page 18. Kindly come to page 31 of the application. Lordship got that, my lord, the third paragraph. With the above undertaking of Sri Debraj Mitru, all the Shebaites are ready to accept him also as one of the members of the Board of Trustees of the Trust Estate. The applicants, as well as all the other Shebaites appearing before this court, have agreed that the aforementioned 4 persons may be appointed as a new trustee of the Trust Board of the Trust Estate. Accordingly, Sri Shoibal Narayan Dev, Sri Dilip Narayan Dev, Sri Taposh Bosh, and Debraj Mitru are appointed as the new trustees of the Board of Trustees of the Trust Estate of Raja Swanso. The said trustees shall discharge their duties in terms of the order dated 7th October 1996, as confirmed by the order dated 9th April 1999. The Board of Trustees, this is important, my lord, the Board of Trustees shall be entitled to act by majority decision of the trustees. This is important. Now kindly come to my affidavit in opposition. Paragraph 12, my lord, page 13. Well, about, my lord, 6 lines from the bottom of that page, page 13. With regard to sale of the properties situated at Mauja
Just a
Shukchar.
minute.
Sorry, my lord, page 13.
Yes, with reference to paragraph 14 to 22.
Yes, well, let kindly come to about 6 lines from the bottom of that page.
With regard to sale of the property.
Yes. With regard to sale of the properties situated at Mauja Shukchar, it is specifically stated that the said 2 properties were fully occupied by local club, illegal occupiers, and descendants of the erstwhile caretaker of the said estate. The said estate not only had any access to the said 2 properties, but also no usufruct could be earned by the said estate from the said onerous properties. Time to time, members of the Board of Trustees and Shebais of the said estate tried to settle the disputes amicably with the said occupiers and to increase income of the said estate therefrom. But the said illegal occupiers never paid any heed to them. our Devattar estate had no control and or authority over the said onerous properties. Thus, any normal procedure of sale by way of auction paper publication could only result as futile. It was clear that any legal initiation and or tussle with regard to the said two properties could only raise unnecessary expenses of the estate without getting anything in return. Ultimately, the said legal heirs of the erstwhile caretaker approached the said estate to transfer the said onerous properties in their name in lieu of certain consideration with a letter dated 12th December 2014 and 8th November 2019. I shall show these letters. In fact, in those said letters, said persons annexed copies of the tax receipts in respect of the said properties which were already recorded in their name with the local municipality and BLLRO office. Without wasting any time for the benefit of the said estate and the said deities, the present Board of Trustees, after taking resolution in one meeting dated such and such, registered the said onerous properties in their favor and entire consideration amount was deposited in the Devattar account for the betterment or upliftment of the said estate. Now kindly turn the page, my lord, once. Page 15 at the top. Be it noted that it should be one club, namely Amra Shobai Sporting Club has served one notice dated such and such upon the Board of Trustees proposing to register in their name by way of deed of gift one illegally occupied property in Shukchar. Now, my lord, kindly come to my supplementary affidavit once. Kindly come to the supplementary affidavit once, my lord. Kindly come to page 109. Annexure F1. মাননীয় মহাশয়, আমরা নরেশচন্দ্র দত্ত মহাশয়ের উত্তরসূরি। তিনি একসময় আপনাদের এস্টেটের শুকচর এবং পানিহাটির খাজনা আদায়কারী হিসেবে কর্মরত ছিলেন। যেখানে খাজনা আদায় করা হতো শুকচরের, সেইখানে আপনাদের অনুমতি সাপেক্ষে নরেশচন্দ্র দত্ত তার পরিবার লইয়া বসবাস করিতেন। তাহার মৃত্যুর পর আমরা তাহার উত্তরসূরি তিনজন শরিক ওই জায়গাটিতে বসবাস করিতেছি। এ যাবৎকাল মিউনিসিপ্যালিটি ট্যাক্স এবং খাজনা প্রদান করিয়া আসিতেছি। এমত অবস্থায় আপনারা যদি দয়া করিয়া আমাদের উক্ত জায়গাটির সত্ত্ব লিখিয়া দেন, তাহলে আমরা বসবাস করিতে পারিব, ইত্যাদি ইত্যাদি। Now kindly come to my lord page 111. Letter of 2019. মাননীয় মহাশয়, আমি শ্রী তাপস দত্ত পানিহাটি শুকচর রাধাকান্ত দেববাহাদুর মহাশয়ের পরিত্যক্ত জমিতে পরিবার লইয়া বসবাস করি। আমার পিতা নরেশচন্দ্র দত্ত আপনাদের এস্টেট 20 বছর যাবৎ কর্মরত নায়েব ছিলেন এবং কর্মরত অবস্থায় 1962 সালে তার মৃত্যু হয়। Kindly take into consideration, my lord, the property.
Prayer for transfer in the name of Bikram Adhikari.
Yes. The property is out of control of this estate, my lord, at least since 1962, for 60 years. Now, my lord, kindly come to my lord page 122. This is the Khajna receipt, my lord, in the name of Taposh Datto. Similarly, my lord, page 125, 128, And these are all of, my lord, at the bottom, lordship will find at least 30 years old. 128, kindly come to the last document.
What did you do at that time?
Sorry, my lord.
What did you do at that time when it came to your notice that the things are occupied by?
They were not there, my lord. These trustees were not there.
That means that some of the existing trustees did not take any step for
It appears.
get it vacated.
It appears. For 60 years, my lord, it has, and interestingly, my lord, lordship has seen my affidavit. Now kindly come to the affidavit in reply. Well, lordship will kindly
Just
take
a
up
minute. Let me go
affidavit
through it.
in reply, my lord. Kindly come to paragraph 13, which deals with my paragraph 12, which I had placed.
Affidavit in reply.
Affidavit in reply, my lord, affirmed by
Dilip Narayan Dev.
yes. On, my lord, 11th or 14th of April 2023.
17th April.
Maybe, my lord. It's not very clear, my lord.
Yes.
Now kindly come to paragraph 13, page 14. With regard to the statements made in paragraph 12 of the opposition, save and except what are matters of record, I deny each and every allegation made therein, and I repeat, etc. I further reiterate that the trust estate is not properly administered and the other three trustees had illegal motive in transferring the properties, and the said trustees had made illegal gains. I further reiterate that Taposh Bush and Debraj Mitra have no beneficial right. I further say that the properties of trust were sold at meager amount, much less than the market value, and even without holding any meeting of the Shebais and also taking any permission from this honorable court. I deny that the trustees had sold the properties for the trust for the benefit of the trust, and the said trust had faced financial stringencies. I deny that no such meeting was held on such and such, and prior to such meeting, no notice was ever served to me, being the one of the members of the board of trustees appointed by this honorable court, and even the minutes of the meeting was never served on me. I say that at the time of such illegal sale, there was no financial stringency in the estate, and the receipt of payment on account of trustees, etc., monetary. My lord, with greatest of respect, my lord, where is the denial of the statements made in paragraph 12 of my application?
Denial of?
The statements made in paragraph 12 that the entire property is occupied by, my lord, local club, illegal occupiers, descendants of the erstwhile caretaker. The estate has no. Kindly come to paragraph 12 of my affidavit in opposition.
Yes, you have mentioned that.
None of this have been denied. None of this has been denied. I will tell your lordship, my lord, the main grievance is the honorarium.
All right.
May I, my lord, kindly give me, my lord, 5-10 minutes time on any other day, my lord, I will conclude my submissions.
Or Mr. Mitro, in part. Fix. Dictate Rakho. For further hearing, present Board of Trustees shall continue to act till further order in accordance with the order passed on when that order was passed,
What I did about it.
13 December.
And
Yes.
thereafter on 2nd May.
Second May is limited
It was limited to a certain extent.
in terms of order dated 13 December 2022.
Lordship.
Item 17. 4, 5, 4, 5 and 17.
4, 5 and 17.
After vacation, Mr. Mitra? Or
Right to
before that?
vacation, my lord.
I
Any day
cannot
prior.
say, my lord, that this matter has such urgency that
The thing is,
either, my lord, your lordship will set aside
Any
the
day
sale
for-
or not. That
any
can
day
be
prior to the vacation, my lord.
Here, ছুটির আগে এই মামলা নিয়ে কি খেচর খেচর করবে?
16th. 16th October.
16th?
October. Or any day prior.
No, no.
I was saying, my lord, after vacation, if it is possible.
If my lord set aside the sale before vacation, that would be beneficial.
That would not be possible because I have to hear Mr. Mitra another day, then to her another day. That cannot be. And this is not be a very short 2-line, 3-line order.
Not 2-line, 3-line order. And my lord, I was humbly beseeching my lord, since the board of trustees have sold the properties, everything has been done without seeking any. The puja is coming. Durga Puja is knocking at the doors, my lord.
So
An
if you-
interim committee may be framed to look after the
That come
puja.
on the next date with the appropriate application. 30th November.
I'm obliged. Both the applications.
3 applications, my lord.
4,
I see.
5,
Three
17. That is
17. GS
5 of 22,
5
GA
of
6 of 22, GA 8 of 23. What is about 8 of 23?
8 of 23 is one of the Sabayats has come up, who has Sabayat's rights has been suspended.
Oh, all right.
My
That-
lord, may I
that-
have your lordship's leave, my lord?
Yes.
No.
Item number 7.
This is my application.
7, my lord, I
You are
appear.
waiting to see this thing.
Yes. And for my turn to come. My lord,
And doing mischief.
no, I didn't do anything. Only when I start doing, Mr. Mitra is on the other side.
Including Mr. Mitra.
No. Can't, my lord, I can't. I've learned a lot from him.
Yes.
My lord,
What is this?
my lord, this is, my lord, in this matter, I appear on behalf of the intervener, my lord. This is an application possibly, my lord,
Just a minute. Let me.
lordship.
But it's an application by a purchaser of a particular flat in this building.
You objected to this. You are.
I objected to this particular sale. My contention is that this particular purchaser, this vendor, my lord, who wants to sell the property doesn't have any right, title and interest.
Have you got a copy?
I've got, yes. In that application taken out by my learned senior.
I
friend, there
also
was a
filed an
directions.
application.
AO, will you file AO?
Yes, the directions have been
একবার
passed.
দেখান।
That time is possibly not over, subject to correction. So we'll file
My
that.
lord, what I respectfully submit, my lord, subject to what falls from your lordship, without hearing my application, this sale order
All right.
cannot be
That will
passed.
be.
Let this application appear along with that
Where is
application.
the application for other application?
My lord,
That is not in the list.
that is due to appear, my lord, on 23rd of November after exchange of affidavits. Let this appear along with this application
Let this
because
application appear on 23rd November along with GA number.
GA number, my lord, 180 of 2023, because my application has to be
All right,
heard, my lord,
it will be hard together.
lordship. Sorry, আপনি কি বললেন? I'm grateful, my lord.
Item number 8.
No, I have to pass a order in your case. See, I am hearing and hearing.
In my favor.
I've heard it long.
Yes, sir. Your lordship.
GA4 is for then,
GA4 is my application.
for that one.
Yes, there's only one application.
GA4 is for injunction, so and so. I have heard you all. I will pass order today.
Fine.
এটা দিয়ে দেবে।
My lord,
I will pass order.
your lordship had directed both of us to file notes.
Would you file?
Notes, my lord, I will file, my lord, if your lordship grants me this week's time, I'll
Let
I'll
me
file.
do it. Let me go through it.
Very well. My lord, the
Would you
argument,
want to file any notes of argument?
Yes, my lord, because that your lordship.
I have passed this order long ago. I have asked you to file notes of argument long ago, at least 1 month ago. What were you doing for all these things? I am giving you 3 days time. If you are able to do that, I am giving you on Monday. Otherwise, I will pass order.
No, I want the submission complete.
Submission was complete. He is supposed to file notes of argument, both of them.
No, submissions were not complete since the
Form
fact.
filed in the form of notes of argument. Put it in the notes of argument. Adjourn to 9th October. Come with the notes. I have heard it long. Number of times I have heard it.
Yes, my lord.
And I have to put an end to this.
Yes. Lord,
Would it be your lordship's pleasure to hear me for 2 minutes on the day when I come?
You again.
So let me justify that I have been briefed at this late stage. Justify my case.
Well, come on Monday
I'll come
Get
with the
ready.
notes, sir.
and finish it.
Only one thing, on the last order, Lordship has recorded that the department is to produce the records as to whether any written statement has been filed in this suit by any of the defendants. I do not know. What I learned from the department is that one of the ledger,
There, let me look at on that next date.
the department can't prepare a report because the ledger is torn. That is what I hear from the department. Well, if the records are there, well, there is no need for a ledger. Well, if the written statement has been filed, it would be there in the record.
Your defendant number?
1.
Have you got a copy of written statement?
I have to check with my advocate.
Because as per the report, different written statement was filed by 2, 5, and 1. But written statement is not available in the record.
That is in this suit or CS number 118.
118.
Yes, that is in 118. But in 1166, where this application has been filed, to our knowledge, no written statement has been filed. But if it's there in the records of the department, we have to
They
inspect.
could not punish anything in this regard. Because ledger is torn.
Yes, that is what I hear.
Then you have to look for whether you have filed written
I'll
statement or not.
confirm it with my.
Come
So
on,
will your
next
lordship
day.
grant us leave to inspect the records in the department so that
In the meantime,
this can be clear?
leave is granted to the parties to inspect record in terms of original site rules.
In 1166, in this suit.
Whenever necessary, you do that.
Very good.
I'm giving liberty.
Actually, the
Then next you come and ask, let me give another leave.
No, I understand. The order is being passed in both the suits
Both the
together.
suits. Both the suits.
Man.
Yes, next.
Great.
Item number 9.
Mr. Dotto, what happened in that case where you are receiver or something, you want to get released?
Milord, yesterday one of the parties approached me. They said that they have circulated a letter, but none of the parties are coming forward to pay the remuneration of the receiver. So I said that better get rid of me, appoint somebody else.
When that is fixed?
Well, that I don't know, but only yesterday they said that I'm circulating a letter to requesting that if they don't come forward, then I have to approach the court. I repeatedly telling them that you are only suffering a prejudice because of my inaction. So therefore, please go and get somebody else appointed who can do it. But Milord, for some reason, Milord, I think they don't want to let me go.
All right. Yes,
Maloti Das matter, Milord. That Maloti Das partition.
Yes.
Much of fighting between the court.
Probate.
No, it's a partition suit, Milord, where a lot of properties were involved.
And some property was in Howrah and some property was in Ultodanga or somewhere near that. Now, my lord, I was asked by the court to see if the Howrah property could be auctioned and sold. I had taken steps to publish, advertise, some offers were there. Thereafter, none of the parties turned up. And my lord, I was
I'm
given.
not blind eye. What is your headache? You need not bother about that. Let the parties come to this court.
Yes, that's what I said. That's what I said. But from time to time, the person who is having the majority of the share comes and pokes me, Mr. Dutt, do something. So what can I do? I'm only an officer of court. Whatever the court directs, I'll do.
You mention it before me, file an application, I will do necessary things.
Okay. Deeply obliged.
Lord, item number 9, my application. Your lordship, GA4.
What GA3 is about?
GA3, my lord, is an application for restoration of, my lord, an application being GA number 3984 of 2007, which was dismissed for default.
GA3 ta dekho.
GA3, my lord, is the old application, my lord, which is for restoration, my lord, of GA 3984, which was dismissed for default by an order of 4th June 2018, my lord.
Order dated 4th June recalled GA 3984 be restored.
My lord.
When it was dismissed, 4th June 18.
Lord, 4th June 2018.
And it was filed on 31st January 20.
It is being contested, my lord.
My lord, your lordship.
This is contested.
Yes, yes. Because they had withdrawn an earlier application, my lord. We had pointed out certain things.
You better you hear it out soon, otherwise it will be destroyed.
My lord, there was some, my lord, difficulty. My lord, I would like to bring before my lord's notice.
Have you annexed this order, 4th June?
Yes, my lord. It is annexed, my lord.
Mr. Kankaria, learned advocate, prayed for leave to retire. Such prayer is allowed and so to, that application was dismissed for default.
Yes, my lord. My lord, prior thereto, my lord, there's an order of 19th November 2019. My lord, where, my lord, there was some difficulty with the advocates and, my lord, which is why, my lord, none was representing the petitioners. As a consequence, my lord, the order of 4th June 2018 was passed. Yeah, Chief, 19 November order.
Have you got a copy of this?
My lord.
Yes, my lord. Yes. But today the application before your lordship is with
My lord,
regards
today,
to
today, my lord, GA4 has been filed, my lord, in the development during pendency, being, my lord, that the respondents in the application, my lord, during pendency has passed away. My lord, substitution is required to be done, my lord, for respondent numbers 1, 2, and 6. GA4 ta notun GA.
Delay of 48 days.
My lord.
My lord.
My lord, may I indicate, my lord, the facts and circumstances in this application is, my lord, that, my lord, by a letter of February 13, I was intimated by my learned friends, advocate on record, my lord, that respondent numbers 2 and 6 have passed away.
Respondent number 2 and 6,
my lord. Your lordship would kindly come to page 10.
And to be substituted as in para 16.
My lord.
Yes, my lord.
Kindly
the
come.
only thing, my lord, I had indicated.
Let me understand.
Very well.
My lord, your lordship would kindly come to page 10 of the application.
Then, so far as defendant number 6 is concerned,
my lord,
it is para 17.
Paragraph 17, my lord.
So your prayer is changed in terms of para 16 and 17.
My lord. And my lord,
and
also,
delay of 48 days.
My lord. For as far as, my lord, there is one more prayer before your lordship, my lord, that is the striking out of the name of the respondent number 1, who was the executor. My lord, the executor having passed away, my lord, no right to sue survives.
So you have basically 4 prayers. One is striking out name of respondent number 1.
My lord.
Substitution of respondent number 2 and 6.
My lord. And my lord, the
condonation of delay.
And my lord, condonation of delay. And my lord, the
necessary amendments be carried out, my lord, as my lord would appear, my lord, from my lord's brief as annexure A, my lord, which commences, my lord, from page 13, my lord. Page 13 of the application, my lord. The necessary amendments are, my lord, marked in red ink, my lord. The department may be directed to carry out the same, my lord, in terms of the prayers made in the master's summons.
Yes.
Lord, I had indicated, my lord, previously, your lordship will recall that I want to file an opposition to this application, my lord. Kindly gives me a direction, and even, my lord, even the delay that is calculated, the defendants have admittedly expired on November and December 2022, September 2022, my lord. Thereafter, my lord, I informed them in February. So, my lord, the delay is much more than what has been explained over here. And my lord, the suit has abated. And on the last occasions also, I had indicated there are certain other points which I need to take in the opposition. Kindly gives me the shortest time, my lord. I'll file an opposition.
Learned counsel appearing for respondent number
6.
6. Grace leave to file affidavit in opposition against GA number 4 of 23. Leave is granted. Full stop. Affidavit in opposition is to be filed within 2 weeks. Affidavit in reply, if any, within 1 week thereafter. The matter will appear in the list on.
My lord, 1 week thereafter, I understand, my lord, subject to correction would be during the vacation. Your lordship, my lord, kindly keeps it 2 days after the vacation. So, my lord, I can affirm within time, my lord.
30th November.
My lord, I appear for defendant number 2 and 6 both.
2 and 6.
Yes.
And so 2 weeks, my lord, my learned friend will hand over the affidavit in opposition, and my lord, before reopening, I will make ready, and on the
That's
reopening
why
date,
30th November. You
my
get enough time.
Only difficulty is with the annual vacations will ensue, my lord. That is
so
the
2 weeks is within
2
the
weeks
vacation.
within vacation. I know.
Within vacation, excluding winning vacation.
Fine.
Very well, my lord. I'll try to.
Obliged, my lord.
Item number 10.
Lordship, I'm appealing for the defendant respondent. I was seeking for an adjournment as
Mr. Dotto was here right now.
yes,
Mr.
but
Dotto was addressing
Mr.
your
Banerjee is not available.
Lord, this matter has been unnecessarily, Lord,
Come on the next week.
lingering.
Lord, any day other than Thursday.
You can't have the same and the other years are waiting. For what day I can say personally. What if
It is a correction.
Prayer of the learned counsel for the defendant matter is adjourned to 9th in October.
Lord, just a small correction. In the order of 1st of September 2023, if my lord kindly takes that order. This is the order, Lord, by which your lordship was pleased to dismiss the application of the intervener. 1st September 2023. Act of corrections are first. I mean, the check copy dobo.
Please put the corrections there.
Yes. Is not AJ is not is it for not হবে. This is the only correction. Look, page 3. The sentence blood starts from page 2, bottom of page 2. My submissions are recorded. Then at the top of page 3,
certain one correction is necessary to make in the order dated 1st September 23. 1st September 2023. First up. In the first paragraph in page 3 of the said order, the word not within quote, not shall be introduced, shall be put between is and a, দুটোই quote করবে. And the sentence and the clause shall run as follow, within quote, a subtenant is not a necessary party.
Achha.
This much.
Yes, this though. Because all the judgments say that. I mean, it must have been a typographical.
Typographical error.
Lost sight.
Let the corrections be made in the server copy also. Yes, you take it back.
আপনাদের কপি আছে তো? ফাইলের কপি আছে?
Item number 11.
I'm for the petitioner, Lordship. Mr. Chaudhary was making submission.
Well, this matter, Lordship would recall, my lord,
I can remember.
But all I have to show today, your Lordship, is the judgments pertaining to limitation. On the last occasion, I had shown to your Lordship
factual aspects.
Yes, the factual aspect I have shown. I have made the analysis of the pleading. I have shown the inconsistent case. One case that blank document, another case I did not read the document. I have shown that the petitioner had executed 5 documents. 2 affidavits, 1 receipt, then on the footnote of the probate petition, all those documents I have shown.
Actually, if you are relying on the limitation issue, and if your limitation issue succeeds, then other matters cannot be looked into.
Yes, that is, my lord, on that, but I have shown prima facie also from the petition, because, my lord,
apart from the question of
because limitation, if we start arguing first, an impression is often given to the court that on merits they have something to hide, therefore they are harping on limitation. Therefore, I have first shown that the case made out doesn't stand even on the own footing as made out in the petition. Now, your Lordship would recall, I had shown your Lordship a receipt where the signature has been made across a revenue stamp. The receipt from the pistol sale, the father had the pistol was sold, and the receipt is mentioning this is in terms of the will, and after the pistol sale, she receives the money by check from the executor. And this is also another aspect, when after probate all these have been done, and even the receipt is there, money given, can there be a question of accounts not being filed? But because the main argument of Mr. Ghosh was that the accounts cannot be found in the record, so therefore the accounts have not been filed, therefore the probate has not come to an end, I can file. Lord, with respect, after 30 years, it is not possible for me. I have complied with, I have the receipts, I have all the supporting documents. But accounts, my lord, it was with Mr. Dey, it has been filed, but my lord, I must be candid, I don't have a copy with me. Otherwise, I would have produced it here and now. But my lord, I had nothing to do. Even if, my lord, to satisfy the court's conscience, the court wants the account, I can reconstruct it and file it today, because so far as the testator's estate and the accounts, because the executrix is still alive. She may be 90, she is affirming affidavit, she is alive, she can file the account. There is nothing to hide. But that can't be a score to reopen the 30 years back probate granted on this, only on this ground, that I am not aware, I have signed all these documents, but these are either blank or I did not read them. This can't be a ground. Now, so far as limitation is concerned, Lordship will find, my lord, the first judgment which I cite, and this I am saying, my lord, when the right first accrues, the right, if any, had accrued to the petitioner when she had signed all those documents, that is number 1. And more importantly, Lord, the receipt which is on a revenue stamp. The receipt is on a revenue stamp, that is not on a blank piece of paper. And that is what defeats the entire case made out in the petition. Petition is an omnibus statement saying I have signed in blank documents, and another line, my lord, 3 lines or 4 lines thereafter, I did not read. My brother asked me, I did not read it. So
I have already made my submission.
Yes, your judgments.
Inconsistent. Now kindly see these judgments. The first judgment which I show your lordship. Kindly takes AIR 2019 Supreme Court 4948.
Justice Arun Mishra's judgment.
Justice Arun Mishra. Kindly first comes to paragraph 7. 4948.
Yes. Next.
Well, at paragraph 7, my lord,
Yes,
lordship.
I have seen this.
Yes. Well, at paragraph 7, lordship has seen just that article 137 applies even if the period spent in notice of motion, petition for revocation was filed beyond period of 3 years, so and so. And well, at para 17, lordship will consider. In the present case, the letters of administration were granted in ancillary proceeding on 25/11/1994. The High Court took note of the fact notice of motion was
Relying on Linet Fernandez case.
yes. And Millard, so far as the Fernandez case is concerned, Millard, just for formality, AIR 2017 Supreme Court.
17.
Fernandez is an earlier case.
Yes, 17.
Yes.
Yes. It came in 2018 in SCC.
Well, very few instances where AIR publication is prior to SCC. Usually it's the reverse. It first comes in SCC and then comes in AIR. But very few, one of the few instances when it has come first. Now, my lord, in the Fernandez case, lordship will kindly see 2 paragraphs. They are paragraphs 13 and 14. Paragraph 13, if my lord is pleased to come to. One must keep in mind that the grant of probate by a competent court operates.
You find one thing, this judgment was delivered in October, 3 judges bench.
Yes.
Subsequently, one judgment was passed by Justice Deepak Mishra very possibly in November. There, their lordship allowed the revocation after 23 years, but that was of 2 judges bench, not 3 judges bench.
My lord, I am not saying, my lord, the test is number 1, article 137 applies. Now, 137 says when the right accrues. If I read 137, it is, my lord, 137 is saying when the right to apply accrues. So,
in case of minority, it is 3 years from the date of majority.
Correct. So, and this is, my lord, any other application for which no period of limitation is provided elsewhere in the division, 3 years when the right to apply accrues. Now, over here, the petitioner has come up with a case that I am not aware of the will, I am not aware of any probate proceedings. I have signed, all these are my signatures, but I have signed them on blank documents or I have not read the documents. This is the case the petitioner has come. To counter that, I have shown to your lordship that it is not a single document that the petitioner has signed. During that relevant period, in that 2 or 3 year period, she has signed at least 4 to 5 documents. And one of them is a receipt which, in respect whereof she has received money by an account pay check, not even cash, account pay check from her mother, which she has signed by executing a receipt on a revenue stamp. So, if a blank document is subsequently converted, my lord, I can't have the signature on top of a revenue stamp. So, if that be the case, and you take 3 years, and that is when the right to apply accrues. So you are taking, and my lord, more importantly, my lord, every case has to be, because my lord, in a grant of probate, not only it operates in rem, my lord, one thing is to be ascertained that the court's conscience is to be satisfied. And my lord, from the petition, I have also shown to your lordship, she was aware of the execution of the will. 2 cases have been made out. This has been drafted by Mr. De. who was the advocate, and he was our family advocate who used to interfere in quarrels of my father and mother. This is one. Second is, my father had instructed him to draft the will. This was drafted. My father, it is as per my father's, but my father had said, don't give effect to it now. So, knowledge of will made by father through Mr. De, the draftsman, and also the attesting witness. I have already shown that. There is no doubt that he was the attesting witness. Also, the attesting witness, knowledge of will is with the applicant. Contemporaneous documents show that, my lord, the CSC, my lord, all those electric meter affidavits, that in terms of the will, it is coming to so and so. I have no objection if the meters are transferred. Contemporaneously, 5 documents are there. One of them is a receipt which has been signed, my lord, on the revenue stamp. It is not a blank document. No question of not reading the lines.
Mr. Ghosh, have you filed notes of argument?
No. Well, once my learned pen finishes.
So, my lord, the story of the knowledge coming from the suit in 2018, once it falls flat, now Lordship will see as per 137, kindly see, my lord, in this case, 2017, my lord. 137 of the Limitation Act, Lordship will find any other application for which no period of limitation is provided elsewhere in the division, it is 3 years when the right to apply accrues. When the right to apply accrues. Well, the 2019 judgment which I showed to your Lordship, paragraph 7, this has been specifically mentioned. Lordship will first see the 2019, Arun Mishra, Justice Mishra's judgment. Paragraph 7, the single judge held that proceedings are covered by Article 137 of Limitation Act, which requires the application to be filed within 3 years from the date when the right to apply accrues. Even if the period spent on the notice of motion from 97 to 98 were excluded for consideration, the petition for revocation was filed beyond the period of 3 years from 25/11/94 as the 3-year period of 24/11/97, and the revocation petition was filed on 21/7/99. The court, after excluding so and so, the learned single judge also held so and so. And then paragraph 17, Lordship will see. The Supreme Court affirms it. And Millard, this is relying on the Fernandez case. Now, Lordship will kindly take AIR 2017-5453, para 13 once.
This is also by Justice Mishra.
Yes. Millard, the first judgment was, Millard, by
Justice Mishra.
Justice Patnaik.
2017.
No, the first 137 applies. My lord, Supreme Court has pronounced, my lord, at least 3 or 4 judgments are there. These 2 are the latest. But first was, my lord, by Justice Patnaik. But kindly see para 13, my lord. In this matter, my lord, I am reading, my lord, from 10 lines from the top. In this matter.
Para 13.
Yes. Of, my lord, the 2017 judgment.
One must keep in the mind.
Yes. My lord, towards the middle, I am reading. In this matter.
In this matter.
As mentioned, Supra, the appellant was a minor at the time of grant of
yes,
probate.
this relates to minority, that I told you.
Majority on so and so. Well, this is, my lord, because, my lord, it has been made flexible because the section says, article says, when the right to apply accrues. In this case, my lord, it is stretching it far. Even if I assume that from minority you attend majority, when your right to apply accrues, then. Here I have already shown she had knowledge not only during the time of execution of the will, but during the entire contemporaneous period and even thereafter, because in terms of the will, she has given a no objection for the electricity meter. And more importantly, in terms of the will, she has received money after the sale of the pistol by executing a receipt on a revenue stamp. At the cost of repetition, I am harping on that. It is not a mere blank piece of paper. And I have shown that in every document she has signed at the relevant portion. It is not that everywhere the signatures are in the same portion and the document has been converted. Somewhere in the middle, somewhere in the side. And along with some of the documents are jointly signed by the mother, the brother and the sister. So merely coming after 30 years and saying, yes, these are my signatures, but I have signed it in blank documents. Well, that can't be, especially when you have signed on a revenue stamp, where you have received payment by check, exactly in terms of the will, with the, which is a part or portion of the sale proceeds of the pistol sale. Now, Millard, kindly, if I may read this para 13 once, Millard, one line. So, my lord, over here, if during that time she was aware, my lord, these lines squarely apply. The appellant did not choose to initiate any proceeding till the year 25/1/1996. That is a good 31 years after she attained majority. My lord, this is another good 30 years or 27 years, my lord, when she has received the money from the pistol sale, which is referring to the will, which is also referring to, my lord, the money that she is getting in terms of the will. A good 27 years, my lord, after she has signed, my lord, the no objection for the electricity meters. And nothing was shown, a bold statement. I thought it is for required for mutation purpose. If you thought it is for mutation purpose, is the property mutated in your name? Are you paying any corporation tax or municipal tax? No. So, my lord, this is really a vague attempt, my lord, which has been made after 30 years. And my lord, I read further, no explanation worthy of acceptance has been offered by the appellant to show as to why she did not approach the court of law within the period of limitation. My lord, here the only explanation is, I have come to know of it during the suit. This is the only stand they have taken. And I have shown, my lord, contemporaneous documents, not one but 5, showing that she was fully aware. My lord, forget the consent which has been signed at the foot of the petition. Let us assume she can be misled. But why 5 times you are misled and you are an educator, you are not a Poddanoshin lady. Making a bold, and how are you misled to sign on top of a revenue stamp? It's not a blank sheet of paper. Anybody who is signing on top of a revenue stamp is, my lord, acknowledging that it is in receipt. And receipt of what? Not cash payment. Payment made by check, check number, particulars, everything given. And received from the mother. That is why, my lord, I say that this, my lord, bogey which has been created, accounts have not been filed. Kindly see all these documents, all supporting documents are all present. And what was produced before your lordship, even the probate is missing.
All right, this is your submission.
Yes, and my lord, these 2 judgments, now, my lord, I will end by showing your lordship, my lord, kindly now takes section 263 once.
Just cause.
Yes, my lord, just cause shall be deemed to exist where, my lord, kindly see clause D. Sorry, clause E. The person to whom the grant was made has willfully and without reasonable cause omitted to exhibit an inventory or account in accordance with provisions of chapter 7. Well, at firstly, there is no averment I have willfully done anything of this sort. Secondly, well, my affidavit will show that not only has she received, my lord, in terms of the will, she has herself executed receipt. Receipt is not in dispute. The signature is not in dispute. Merely try to, whenever a signature is being confronted, she is taking the same stand. Oh, I have signed it because my brother had asked. So there is no question of, my lord, willfully doing it. If, my lord, there was a willful attempt, I wouldn't have shown anything to her. So, my lord, this clause doesn't come into the picture at all. My lord, I read it again. The person to whom the grant was made has willfully and without reasonable cause omitted to exhibit an inventory. My lord, which inventory has been omitted over here? Nothing stated in the petition. or account in accordance with the provisions of chapter. Account is missing is only an assumption being made from this side. But after 30 years, it is difficult. And if lordships wants, my lord, for my lord's conscience, I can, my lord, all the supporting documents are here. I'll recreate it and submit it again. Because in terms of this is only for the court satisfaction. My lord, I can understand, my lord, why this provision is there. My lord, there are two terms which have been used: revocation or annulment. My lord, suppose the testator has, my lord, 3 properties. 2 properties are reflected and, my lord, it has been distributed in terms of the will. 1 property has not been done and accounts have not been filed. A beneficiary comes and says, well, I get this property in terms of the will. I have not got it in terms of the will and accounts have not been filed. Then question of, my lord, either you are put to terms or there is a threatening of annulment. A person cannot just wake up after 30 years and suddenly decide, because I don't have a case in the partition suit, I come up and challenge the will, when there are contemporaneous 5 documents. Well, I read it again. Omitted to exhibit an inventory. So inventory is not an case. It is only accounts, restricted to accounts in accordance with the provision of chapter 7, or has exhibited under the chapter an inventory or account which is untrue in a material respect. Nothing has been shown that any account is untrue. A statement is made from the bar that the estate did not have so much of money. How did the money come? How did the money come? Particulars have to be given. But my lord, more importantly, my lord, kindly look at those 5 documents. Those, my lord, in my respectful submission, are sufficient to, my lord, dismiss this application. Firstly, on the ground of limitation. Secondly, my lord, on the ground that, my lord, no, it is not covered under 263, particularly when you have received money in terms of the will and you have executed discharge documents in respect thereof.
All right. Next, Mr. Ghosh, file notes of argument.
Yes, but I'll give a reply to these 2 cases.
Well, put it in your notes of argument,
No,
better.
Only one thing, my lord, if my lord sees paragraph 25 of my petition, the applicant states that the person to whom the grant was made has willfully and without reasonable cause omitted. So just what my learned friend, there's no averment, that is not correct. I have taken this
I
point
said no particulars.
square till now. This is the 9th day of hearing. They have not said that they have filed the inventory. They have not said it in the affidavit or the accounts. If that is not so, I have a continuing cause of action. Even today, I can file so the limitation gets taken care of there only. And it's a specific ground under 263D. If the inventory, I can't have filed a suit earlier. There was so much time. He still has the right to file the inventory. So my cause of action is alive that till the time I filed this petition, he had not filed an inventory and accounts as required under 317.
Was there any report called for from the register?
Yes, your lordship had called to report. It's not there. All the documents are there. It is not there. So that point will take care of. It's a ground under revocation
That
as well as it takes care of limitation.
The probate is also not there. So
the probate must be with him. The grant, the original grant is with him.
But probate is also missing.
Anyway, my lord, I'll make my notes and come back and file the notes. And if just to distinguish these 2 cases. So even if he files it today, I'll have 3 years from today to file a revocation. If it is not true, because your lordship will remember, I showed the assets. This gentleman who worked for Tata as an executive has cash, except bank accounts nil, fixed deposits nil, everything.
These are coming from the bar, my lord.
No, they're there. My
pleading
pleading is
Let
there.
him give particulars with the name of the account. Vague pleading will not.
Register shall submit a report.
My report he has given. He has said
that is in respect of inventory and account.
Yes.
For probate.
Well, I don't know. Of course, it will be tested, my lord. But the probate, I remember once the original probate was lost. They don't keep a copy of them. We can't get a certified copy, at least from district courts. They're the original English department. Certified copy.
On
original will. Original.
shall submit the probate before this court on the next date. Along with the report. Heard Mr. Chaudhary, both the parties are at liberty to file notes of argument on or before the returnable date. Let the matter appear in the list on 12th October. Mr. Chaudhary, you take it back and file with the notes compilation.
এই দুটো আমি যাচ্ছি নোটটা দেখার সময় আমি দেখব। হ্যাঁ নিন
Item number 12.
May it please your lordship.
You are arguing.
Well, again.
No. Just, no, nothing to worry about.
No, I'm
On
not
the- on
saying
the-
worrying.
On the last
Thing is, I
occasion,
was in the middle of arguments,
no,
distinguishing his judgments. In
the
reply.
note that was directed to be filed, my lord, we have prepared on the last occasion. The judgments were not there annexed, so may I just hand it over to your lordship?
All the judgments are there.
Yes, my lord. There's also an index. Soon after the note finishes, my lord, there's an index
All right.
which indicates the pages of the respective judgments. This was only what I wanted to hand over. Here.
চারখানা judgment দিয়েছে তো তুমি।
No.
হ্যাঁ?
There are 9 judgments. Written notes mentions all the judgments. You see, whatever judgments are there mentioned in the written notes have all been annexed.
This is your notes of argument as well as judgment.
Yes, ma'am. That was the direction of my lord.
No, আমাদের notes তো- এটা দিয়ে দিই দেখে নিয়েছো Willard, may I hand up my written notes?
Yes.
Now, Millard, I was in the process of Millard distinguishing the judgments which my learned friends have cited. As I could find Millard, today my junior says that they have given 5 judgments, but I see they have given 9 judgments. But so far as okay, so far as the judgments are concerned, my learned friends have taken 2 primary and principal grounds and maybe the only grounds. One is waiver, and the other is the jurisdiction of the court to pass such orders. Now, Millard, these judgments were cited on the premise that A, the process was not followed for the purpose of Millard of instituting a suit. An originating summons suit was filed, which was Millard, if might come back to your lordship, which was sought to be converted into a suit.
And was converted.
And was converted into a suit. And that is one of the points that has been taken, that the originating summons suit is no more there. It has become CS number, and therefore there is no originating summons suit. To that, my answer would be, Millard, if it's a CS or an OS, the nomenclature doesn't decide the contents. So if it is a CS, or if it's an ordinary suit governed under the Civil Procedure Code, then it has to follow the purpose of Order 7. It has to be a plaint, there has to be a prayer, and in the present petition which is before your lordship, although the cause title shows CS, but there is no prayer, because that was an originating summons and the intention of the petitioner was to file an originating summons. Now, subsequently, the court found that originating summons, the issues raised cannot be decided. But Millard, in its own wisdom, Millard transferred it into a suit, which I say is Millard in violation of law without jurisdiction and cannot be granted. That was my first point. To that, my learned friend's argument is that even if that be so, there is a waiver because I have subsequently participated and complied with the directions of the court. And I have
There
not
cannot be waiver against statute.
number one. Number two is when you say there is a waiver, when you take the defense of a waiver, you say that something wrong has been done which you have not objected to. And therefore, by virtue of your not objecting to, you are subsequently stopped from contending that there was a wrong done, because at that point of time you did not object. And I have altered my position on the basis that you have not objected. Now, my lord, none of these three things, my lord, with respect, my lord, to my learned friend client will apply to the facts of the present case. Today, my lord, if my learned friend files a writ petition in the form of a CS, and I don't object to it, and I say that let it be heard on merits, that will not vest the court with the jurisdiction to hear it. This is something, even if I don't object, the court lacks inherent jurisdiction to hear it because it has to go before the appropriate process. Now, in that light, I said that if that be so, then all the orders that were passed by the court hearing suits, at that point of time, he did not have the jurisdiction to pass these orders because it's an originating summons suit is always being heard by the interlocutory court. And I had annexed the list at that point of time. It's the interlocutory court who has jurisdiction, had jurisdiction. To that, my learned friend has cited a judgment which says that the Chief Justice has jurisdiction under the rules to pass administrative orders. And it is not a case of inherent lack of jurisdiction.
That is not an issue.
Millard, now, Millard, if I may just show your lordship, Millard, the three judgments which my learned friend have cited. Millard, your lordship would be pleased to take up the first judgment which my learned friend has cited, reported in. Judgment gulo amada kore dekchi na. Lordship, gives me a moment. I put you know. Lordship. No, no. It's marked. That's shown bole lekha ache. Ridiculous. Will not kindly take up the first judgment which my learned friend has cited, reported in 2004, volume 8 Supreme Court cases, page 229. I believe it will be in his compilation or compilation to the.
Article 364 of the compile. 864 of the written note that they have. Serial number 6. Serial number 6.
Krishna Bahadur.
Krishna Bahadur versus Purno Theatre and others. Will you kindly see what were the facts of the case? Paragraph 2. The case at hand had a checkered history. The appellant hearing was appointed in the post of a messenger cum bearer in the establishment of the respondent hearing, a cinema house, on March 1978. He was subsequently confirmed on the said post. A disciplinary proceeding was initiated against him wherein he was found guilty, whereupon he was dismissed from services. The said order of dismissal was the subject matter of an industrial dispute. The industrial tribunal, by reason of an award, set aside the order of dismissal with full back wages and compensation. On or about May 1991, the appellant was permitted to join his duties, but back wages were not paid. He was, however, retrenched from services within 1 month from his joining, that is on 30th May 1991. A sum of 9030 was paid as retrenchment compensation, which the appellant is said to have received under protest. A trade union known under the Bengal Motion Pictures Employees Union took up the cause of the appellant inter alia on
This
the
is
ground.
concerned with right can be waived by a party. Next.
Now, my lord, he accepted the check. Kindly, my lord, see that last 3 lines, if I may be permitted. He had accepted a check for the aforesaid sum of 9030 issued by the management allegedly as part
This is
payment.
concerned with right conferred to a party. That is separate thing. Next. Some benefit given to the party.
Yes, but here ultimately, my lord, when this
Para 10, that is in para 10.
yes, that was the argument. A right can be waived by a party for whose benefit certain requirements or conditions have been provided by a statute, subject to the condition that no public interest is involved therein. Whenever waiver is pleaded, it is for the party pleading the same to show that an agreement waiving the right in consideration of some compromise came into being. Statutory right, however, may not be waived by his conduct. This distinguishes. And ultimately, my lord, for the reasons, paragraph 18, for the reasons aforesaid, the impugned judgment of the division bench, where, my lord, it had held that it can be waived, cannot be upheld. It is set aside accordingly, and the judgment of the learned single judge upholding the award passed by the industrial tribunal is restored. The appeal is allowed. Now, my lord, the ground, the contention was, if I may say so, if I may just show your lordship that one paragraph. My lord, I was in paragraph 3. A writ petition was filed by the respondent hearing questioning the correctness or otherwise of the said award before the Calcutta High Court, which was marked as writ petition. The said writ petition was dismissed by the learned single judge. The respondent preferred an appeal before the division bench. High Court marked as appeal. Now, a plea as regards compliance with the requirement law on the part of the employer was raised for the first time. Accepting the plea, the division bench, by reason of the impugned order, impugned judgment, allowed the appeal, which was set aside by the Supreme Court. So, my lord, here also, the principle which my lord is saying is that if it's a statute, then there cannot be any question of waiver. Now, here, my lord, all the points that I have taken, my lord, are lack of statutory compliance. I don't ask him to, I don't get a right if he doesn't comply. I get the right to show to the court that the statute has not been complied with. It's not my personal right. If he wants to file, if he has a grievance against me, he has to file a suit. If he files a suit without complying with the procedure of, see, he is in violation of the statute. He is not in violation of any right of mine. I, in defense, show to the court that, look, here is a person who has come before the court who is not complied with the mandatory provisions of the statute. So where does the question of waiver arise in the first place? It's not my right. It's his mandatory requirement, is his obligation to comply with the mandatory requirements, which is lacking over here. In the same lines, my lord, my learned friend has relied upon 2005, volume 7, Supreme Court case.
This is in page?
Page, my lord, I know. This is 2005, volume 7, Supreme Court cases, page 791.
Yes, that is 18 lines. Serial number 2. Serial number 2.
Arshad Chimanlal Modi.
My lord, versus DLF Universal. I believe my learned friend relied upon paragraph 30, right?
Yes. Lack of jurisdiction.
Yes. My learned friend had relied upon paragraph 30. We are unable to hold the contention. The jurisdiction of a court may be classified in several categories. Willard, the facts my learned friend has not placed, and the facts also do not apply to the facts of this case, but the proposition. The important categories are territorial or local jurisdiction, pecuniary jurisdiction, and jurisdiction over the subject matter. So far as territorial and pecuniary jurisdictions are concerned, objection to such jurisdiction has to be taken at the earliest possible opportunity, and in any case at or before the settlement of issues. The law is well settled on the point that if such objection is not taken at the earliest, it cannot be allowed to be taken at the
You are reading out paragraph?
I reading out paragraph 30, which my learned friend has just placed.
Yes.
My lord, paragraph 30, if I may just once again particular. We are unable to uphold the contention. The jurisdiction of a court may be classified into several categories. The important categories are territorial or local jurisdiction. It is not applicable here. Pecuniary jurisdiction, it is also not applicable here. I also don't know, my lord, whether the court fees have to be paid. And jurisdiction over the subject matter. So far as territorial and pecuniary jurisdiction are concerned, objection to such jurisdiction has to be taken at the earliest possible opportunity, in any case at or before the settlement of issues.
Come to para 32.
Yes.
Next.
Next, Willard, the next judgment which my learned friend cited is 2002 volume 4 Supreme Court cases, page 316. I believe my learned friend had
Serial number 5 at page 53. Serial number 5.
Commissioner of Customs.
Yes. Here, Millard, also the argument of waiver was rejected. Ultimately.
Paragraph?
Millard, my learned friend has relied upon paragraph 11. Paragraph 11.
Paragraph 11 to that.
In fact, Millard, paragraph 10, the last line he says is mandate in case of so-and-so versus so-and-so, it was held that even though requirement of 35 of the Bengal Moneylenders Act is mandatory in nature, such mandatory requirement could be waived by a party concerned. On a true construction of 35 of the Act, this court held that the said section is intact only for the benefit of the judgment debtor, and therefore he can waive the right conferred upon him under that said section. This is what, Millard, your lordship just pointed out. It's not a personal right of yours. It's a right which the statute requires him to comply. Now, in paragraph 11, my learned friend says he relies on the paragraph 11 to show that in S. Raghubir versus so-and-so, this court negated an argument that the requirement of 94 based on the principle of that public policy cannot be waived. Rejecting the said argument, this court held that the privilege conferred or a right created by a statute only for the benefit of an individual, he can waive. It also held that where a prohibition enacted is founded on a public policy, courts should be slow to apply the doctrine of waiver. But if such privilege granted under the Act is for the sole benefit of an individual, as in the case under section 94 of the Representative People's Act, the person in whose benefit the privilege was enacted has a right to waive it because the very concept of privilege has a right of waiver. Now, thereafter, my lord, if your lordship sees paragraph 15, bearing in mind the above decided principle in law, if you consider the mandatory requirements of issuance of notice under section 28 of the Act, it will be seen that the requirement is by the statute solely for the benefit of the individual concerned. Therefore, he can waive the right. In other words, this section casts a duty on the officer to issue a notice to the person concerned of the proposed action to be taken. This is not in the nature of a public notice, nor any person other than the person against whom the proceedings are initiated has a right for such notice. Thus, this right of notice being personal to the person concerned, the same can be waived by the person.
Yes, next judgment.
Now, my lord, one judgment, my lord, I had referred to. This, my lord, it's a compilation.
69.
সোহনলাল ভাইয়ের আছে তো আরেকটা জাজমেন্ট আছে দেখো ওরা রাজস্থান হাইকোর্ট যেটা দেখালো ওখানেই আছে তুমি ঢুকিয়ে রেখেছো the other judgment which my learned friend had cited আমার লেখা আছে দেখো বার করো না রে বাবা আমার কাছে প্যারাগ্রাফ the other judgment which my learned friend has cited is 1998 volume 3 Supreme Court cases page 72.
Serial number one, page one. Serial number.
This is Millard trying to counter the argument which I had made that at that point of time, these directions which were passed by the court ঠিক judgment দেখিয়েছে কিন্তু compilation ইন্ডেক্সটা কতগুলো ডিস্টিংগুইশ করলে আর কি বাকি আছে Your Lordship Millard is at paragraph 2. The question here is the Chief Justice in exercise of powers available to him under Article 220 of the Constitution has made rules known as Rajasthan High Court Conditions of Service of Staff Rules 1953, which have been amended by him from time to time by administrative orders. The promotion on the post in question is regulated by these rules. So this is below the rules which govern the service conditions of the employees of the High Court at Rajasthan. There below this question arose whether of waiver. Your Lordship Millard comes to paragraph 15 onwards. This I believe my learned friend will rely on this. Thus, the Chief Justice continued with the highest authority so far as the High Court staff was concerned. This is regarding staff. When Constitution came into existence, the powers and status of the Chief Justice available under both the acts, namely the Government of India Act 1915 and 35 were maintained. Chapter 5 of the Constitution relates to the High Courts in the states under the Constitution scheme. There has to be a High Court for the state, Article 16. Then Millard, rest is not very relevant. 229 has been set out. Appointments of officers and servants of the High Court shall be made by the Chief Justice of the High Court or such other judge or officer of the court as he may direct, provided that the governor of the state may by rule require such case to be specified. Then Millard, thereafter, Lordship turns the page to 81. This article also confers rule-making power on the Chief Justice for regulating the conditions of service of the officers and servants of the High Court, subject to the condition that if rules regulate to salaries, allowances, leave or pension, they have to have the approval of the governor of the state. If the legislature of the state has made bylaws, the rules made by the Chief Justice operate subject to the conditions made in law. Millard, with
But the
respect,
issue of waiver is discussed.
no. Here, Millard, they wanted to show that the Chief Justice, Millard, because this point I had argued and brought before your Lordship's notice, that it is the Chief Justice who constitutes the determination of the court. And it is the ultimate authority. And I tried to argue that all those directions that were passed by a court which did not have the determination to consider an originating summons suit. So therefore, all those judgments, all those orders, which my learned friends say that I have accepted and there is a waiver on my part, they are void. I wanted to assist the court to the extent by saying that they are void and they are non-est. To that, my learned friend has cited this judgment to say that this power of the Chief Justice over the High Court. I believe my learned friend has relied upon paragraph 26, last portion. The conferment of power exclusively on the Chief Justice is necessary so that various courts comprising of the judges sitting alone or the division bench, etc., work in a coordinated manner, and the jurisdiction of one court is not overlapped by the other court. If the judges were free to choose their jurisdiction or choice was given to them to do whatever the case they may like to hear and decide, the machinery of the court would collapse and the judicial functioning of the court would cease by generation of internal strife on account of hankering for a particular jurisdiction on a particular case. Has your lordship got it, Millard, that paragraph? The nucleus for proper functioning of the court is the self and judicial discipline of judges, which is sought to be achieved by the rules of court by placing in the hands of the Chief Justice full authority and power to distribute work to the judges and to regulate their jurisdiction and settings. Now, Millard, apropos this, there is a judgment of our court in the case of Sohanlal Vaid versus State of Vaid. There's very question arose as to what happens to orders which are passed without jurisdiction, without determination.
In reply, my lord, my learned friend is dealing
I had
with the
referred to-
judgment. I think
Yes.
I should get an opportunity.
Well, it's the first judgment annexed to my note. This is regarding our High Court, Millard.
Sohanlal.
Sohanlal. AIR 1990 Calcutta 168. I will only trouble your lordship with paragraph 23 and 24 last line. The foregoing review of the constitutional and statutory provisions and the case law on the subject leaves no room for doubt or debate that once the Chief Justice has determined what judges of the court are to sit alone or to constitute the several division courts and has located the judicial business of the coast amongst them, the power and the jurisdiction to take cognizance of the respective classes or categories of cases presented in a formal way for their decision according to such determination is acquired. To put it negatively, the power and jurisdiction to take cognizance of and to hear specified categories or classes of cases and to adjudicate and exercise any judicial power in respect of them is derived only from the determination made by the Chief Justice in exercise of his constitutional, statutory and inherent power, and from no other source. And no case which is not covered by such determination can be entertained, dealt with or decided by the judges sitting singly or in division courts till such determination remains operative. Till any determination made by the Chief Justice lasts, no judge who sits singly can sit in a division bench, nor can a division bench be split up and one or both of the judges constituting such bench sit singly or constitute a division bench with another judge and take up another kind of judicial business. Even cases where they're required to be heard, only a particular judge sits the division bench, such as parted matters, review cases, etc., cannot be heard unless the judge concerned is sitting singly or same division bench has assembled and the same has been taking up judicial business under the external. Such reconstituted benches can take away only if the Chief Justice specially determines accordingly. Then the observations of the Allahabad High Court. Then Millard, paragraph 24. It is pertinent to remember that jurisdiction of the court may be qualified or restricted by a variety of circumstances. Thus, the jurisdiction may have to be considered with reference to the value, place, nature, and subject matter and the age of the case. The power of the court may be exercised within the defined territorial limits. It may have to be qualified or confined to subject matter of prescribed value. The court may have competence to deal only with cases of specified character, for instance, testamentary or matrimonial appeals, revisions or writs, or specified subjects such as land or service, and so on and so forth. The jurisdiction may be further restricted with reference to the age of the. And the last line, Millard. The cardinal position cannot be overlooked that before jurisdiction over the subject matter is exercised, the case must be legally brought before the concerned court for hearing and determination, and that a judgment pronounced by the court without investment of jurisdiction is void. That is what I was trying to. So all those.
Your point is there is existing jurisdiction and that is distributed.
Yes, Millard. My point was that if there is an originating summons suit, it could not have gone before the court taking civil suits. At that point of time, the court concerned was taking civil suits. It didn't have the jurisdiction to take up originating summons. And it did not have the jurisdiction to convert that originating summons suit into a civil suit by merely changing the nomenclature.
Distribution of business is one thing, passing order or following the rules of original side rule in exercising that determination judicially is another thing. That is your point.
And if on the date you don't have that determination, then
even if the determination means the exercise of business, distribution of business.
yes,
But your submission is, even though there is distribution of business, that distribution of business doesn't mean you have to pass any order which you have no authority to do.
and if you have done so, and even if I have acted on it, if it's void, it's void. So no amount of waiver, waiver or participating or acting in the order will give any legal force to that order.
All right, next.
This is what we had cited, or they are also stating this.
নতুন দিয়েছে নোটে
Anyway, come on the next set.
No,
You
no,
file your notes.
My junior says that
my
there are
no, no.
4 judgments which are referred in the notes,
Yes,
but
yes.
were not placed. If my learned friend is placing on it, I'll get a chance to distinguish it. That's it.
Heard Mr. Dotto in part. Not before Puja vacation.
My lord,
I have
one
almost-
day, I suppose one day would allow us to finish.
Give me 10 minutes on any day, my lord, I'll finish.
And my lord, your lordship will kindly give
13th
me
October.
your lordship will kindly give me an opportunity of dealing with whatever
13th
submissions.
October. After vacation. Your opportunity will be after vacation.
Forget. Rahul,
Because I have to dictate it.
we appreciate, my lord, if we could
We have
finish
given-
the submissions and thereafter your lordship would keep it for
I have only 2 weeks possibly.
whatever your lordship pleases. We leave it to you.
I will try anyway. 13.
Item 13, actually, no, no, 14th I am not here. 13th I will not, 13th I will not be here,
Which one you prefer?
but any other day.
Then after vacation.
Well, one day before the vacation, my lord, the matter is pending since long. Since quite
16th October.
16th. I'm deeply obliged.
Lordship, 13, serial number 13, Lordship, I'm appearing for the plaintiff.
This is the matter where there was direction for reconstruction of records. Some applications were missing. My lord, on the last date, my lord has passed an order with regard to GA number 7 of 2003 and GA number 15 of 2015. My lord, the plaintiffs have served a copy of the records, my lord, on us, GA 15, but the affidavit and the affidavits, as in the opposition and reply, were not there. We have been able to trace out the opposition and reply filed in GA number 15, which my lord has recorded in the last order.
Today are you ready for hearing or I will
No,
adjourn
my
it?
lord,
Lordship will
we have to give copies of this in my lord's records. The my lord's records also won't have the copies of the opposition and reply. So if these
15 pages.
Copies of opposition and replies of GA number
15 of 2015.
15 of 2015 are placed before this court.
Lordship, the copies may be served upon us also. We do
Copies
not have it.
should be served upon the adversary. Let the matter appear in the list on 6th December.
With respect to 7, Lordship, GA number 7.
Come on the next date.
Lordship, GA number 7 of 2003, Lordship. Those affidavits also I do not have. Kindly directs the defendant.
We also don't have the copies, my lord. 15 we could trace out, my lord. We are
Let it be taken up on the next date.
very well. Great.
14.
But they are unstamped, so your lordship will grant them
At the time of hearing, I have other matters, please.
stamp on the pleadings, my lord, the affidavit which was filed. So
Without stamp.
my lord, unless your lordship grants leave, it cannot be reconstructed. So therefore, give us leave to stamp and punch. That's it, my lord.
Leave was not granted for reconstruction.
Lordship, may I indicate original affidavits which were filed has been misplaced.
Let me see the orders.
These are the fresh copies of the original. Lordship, the stamp punching needs to be done afresh. Lordship will remember several applications were filed. However, the plaintiff's applications were treated as
This GA number 15 of 15.
15 of 15.
Yes.
Lordship, the affidavits I do not have, although it was filed by me.
Department was given direction to reconstruct the record.
Yes,
You
Lordship.
file it in the department. Provide copies to the department, file in the department. They will check it.
My lord, leave may be granted to
Leave
stamp
is granted. There is leave granted.
My lord, after that, it has been reconstructed by the plaintiff. My lord, I am appearing for respondent.
Defendant. He is appearing for
So
the defendant.
therefore, I need
Leave is granted to to the learned counsel for the defendant to place the copies of cause paper before the department for reconstruction.
Lordship, for both 7 and 15. Lordship.
In
GA
GA
7
15
and
or 15. Leave is also granted to file cause papers by the defendant.
Yes.
If any, because we don't have that.
By the defendant, leave is granted. You can use to file copies of the affidavits along with the application of GA 7 of 2003 before the department for reconstruction.
Item
Lordship
14,
has kept it after the vacation. Lordship has kept it after the vacation.
Yes.
Yeah, I'm good.
কবে বললাম? 6 December.
Your Lordship, I'm appearing on behalf of the plaintiff. My senior, Mrs. Manju Agarwal, she's out, not in Calcutta.
For one of the defendants, my lord, yes, my lord, she had informed, my lord, she is not in Calcutta, my lord.
Adjourned to 5th December.
Grateful, Your Lordship.
item 15,
In item 15, we are appearing for the defendant bullet. We had filed an application GA5 in which directions for affidavits were filed, were passed. May I have my lord's leave to file my affidavit in reply?
What this GA5 is about?
We have filed, made this application, my lord, for seeking, my lord, time to file our written statement, my lord, much after the writ of summons was served upon us. My lord.
Where is
The
the
short
application?
case.
Where is GA5? Passover. I'm making it not today. Come tomorrow. It is not traceable in the record.
Obliged.
My lord, can it be on Friday instead of tomorrow?
This one, 15.
Yes.
Adjourned to Friday is
6th October, my lord.
6th October. 6th October.
Obliged.
item 16,
My lord, a restoration application, suit for declaration, my lord, an injunction in respect of a family trust, my lord.
GA4 is for?
For restoration, my lord. Only a simple application for restoration.
But I appear for the purchaser who has purchased the entire property. And last occasion, my lord, I had appeared, the other side couldn't, under some reasons. But I may be served with a copy of the application that is being.
Restoration application.
But I
in
do
fact-
not know what is the
Are you
restoration.
a party here?
No.
I am
He
not
is
a
not
party, but
Then
there
you
is,
let you be party first, then I will see.
but there was previous representation on my part that were all
It will
considered
be
by.
restored, my lord, then he can agitate, he can come up
Those
with an
were all
application.
considered, but I have a primary point that none of the plaintiffs or the defendants are alive.
This is an
So there are certain things which have to be looked
restoration,
into.
my lord, only my lord will see that whether there is a sufficient cause for restoration.
But the plaintiff is
Preserve his energy, my
the
lord, while the
plaintiff
suit is being heard, my lord.
so very in discomfort to serve me a copy.
No,
Something is
nothing
fishy.
discomfort. You be first a party.
Something is fishy.
Aye.
You are not a party here.
Yes.
Gautam Malik is not a party here. Who is the Gautam Malik?
Son of the, my lord, of the original plaintiff number 1, my lord.
Which order you want to seek for? You seek for restoration.
My lord, will kindly see its order is annexed at page. It's
16 September.
yes. Restoration, none appeared on behalf of the parties, my lord. Matter got dismissed for default, my lord. Seeking restoration of this.
Now your point is that none of the legal heirs are surviving.
That is the first point. But the second thing is, when the matter was restored earlier, I was given a right of audience. But that order is passed by, showing my lordship the order. আপনার কাছে নেই? But I have purchased the entire property. The suit was originally dismissed in the year 1997. Thereafter, it was restored. But in the meantime, the property was sold and transferred, and I became the purchaser. But subsequent to that, all the parties to the suit died. But that is recorded in an order, but passed in this court, my lord. Lordship has the entire, perhaps doesn't have the entire order sheet before your lordship, my lord.
Why you want to restore this?
Justice Shivakant Prasad.
Restoration, my lord, the suit is required to be adjudicated on merits, my lord. I don't think so, my lord. Whatever points my learned friend has, my lord, he can come up with an application for addition of party and he can agitate those points, my lord. Certainly, no one is depriving him of the right of audience. He can come up with an application with addition of party.
Let the suit be restored. You come with
the
appropriate application.
Kindly appreciates, my lord. My lord,
The way
kindly.
of restoration of the suit. Why is under the?
But he is making a wrong claim before the court. But I should say this.
Not the wrong claim.
Take him here.
But there is an order passed by Justice Shivakant Prasad restoring the order of dismissal that was dismissed in the year 1997. At that point of time, I was heard at length, and the order was passed after giving reasons that only one of them was still alive. Thereafter, one of the plaintiff who was alive, he has also died. Now, what will be the repercussion in the trust? How it would continue or not? But without going into all these details, he is not even serving me a copy of that application.
Until the suit
Lordship,
Why are you intervening?
a copy can be served to me so that I can ascertain what he is asking for.
No,
Who is
look,
the person, my lord?
I understand your contention.
Lordship.
I am hearing an application for restoration of this suit.
Lordship.
Is there any scope to go into all these things?
Yes, my lord, because this was originally a trust.
Might be. Let
My
the
lord,
suit be restored, then all these points would be considered.
my lord, if it is restored, my lord, in that event, at that juncture, my lord, I should be heard. I have
Definitely, if the suit is restored, if he has something to say, I will definitely allow you to appear in the suit. If you are not party, intervention application is to be needed.
but that has all been recorded. That has all been recorded.
That is not binding on this court, first thing.
No, my
Second
lord,
thing, I am not.
my lord, in this suit, in that order.
Which order?
My lord, Justice Shivakant Prasad's order. But the lordship doesn't have the entire order sheet with your lordship in this brief, my lord. Justice Shivakant Prasad's order. Justice Ashish Kumar Chakraborty's order. Justice Saraf's order.
The entire record is not placed before this court today. The learned register original site is directed to place the record with previous order sheets before this court. Let the matter appear in the list on 13th October. Come on,
Let them serve a copy, my lord. I shall try to. My lord,
copy may be served in the meantime.
Copy or not, my lord.
All right, copy may be served in the meantime to the learned counsel appearing for the intervener,
purchasers. My lord,
the subsequent purchaser.
Lordship. I'm grateful. Item 23.
Yes, my lord. I am appearing on behalf of the defendant number 9A.
Why you are appearing?
I am
9A.
appearing on
behalf of the plaintiff, my lord.
Petitioner is
I'm
the plaintiff. I am supporting him.
I'm application appearing
on date of.
I filed the application, substitution application, GA number 60.
On date of original defendant number 4, substitution prayed for.
My lord,
This is normal thing.
If I may indicate, my lord, on 14th of July, the defendant number 1A informed the court that the defendant number 4 has passed away. in the month of April.
Normal.
The petitioner was not, the plaintiff was not aware of the demise of the defendant number 4. My lord, within the 30 days, I have taken out an application. So, my lord, immediately I have taken steps.
This is your application.
My application, my lord.
You should not stand on the way.
And my lord, I should indicate one more thing, my lord. I've annexed the plaint and everything.
Yes.
Number 1A, my lord. I would have consented to this, my lord.
You have no objection.
Otherwise, no objection. But only one thing I would like to point out, your lordship. Your lordship may kindly take up the last amended plaint. The last amended plaint at page 54, at page 38, your lordship will find.
What are you going to
38.
38 of plaint
No.
or petition.
What is this?
This is the last amended plaint.
Last time.
Here your lordship will find, as it appears at page 54 of the present application, that is at paragraph small Roman 5.
Page 54.
Page 54 of this application and page 39 of the application, last amended plaint I have handed over to you. There, without permission, I see that incorporations have been made in this plaint.
And my lord will only see the nature of incorporation that I have
Without
indicated.
how
I will come to that. I was about to place this to before my lord.
Without without permission from the court, the complaint can
Let
be
the
amended.
petition be, let the petition be placed by the petitioner.
Which one?
The lordship will find that Mrs. Akhtari Begum, there was no since deceased.
Yes.
It was incorporated in this plaint. How could that be done? Thereafter, criminal case.
You file an application for separate application for that. If it is so,
yes.
you can file separate application for that. For the timing, we are concerned with substitution only.
But they are
My lord will only take.
You file an.
of a different plaint, my lord. This is not
My lord, if I may indicate, my lord,
So you file that application. That part may be expunged.
Yes.
If that is so, that part may be expunged.
Yes.
Then again,
my lord, it is a fact that Akhtari Begum is dead, my lord. It is a fact. And she was not a plaintiff. She was a party.
If it is so, any change in the plaint is to be made with prior permission of the court.
I have sought that permission. In my pleadings, my lord, I have sought that permission.
Without marking.
But there is.
Was it done?
My lord?
Was it done?
No. Akhtari Begum has passed away subsequently. Subsequent to the previous
You have
amendment.
mentioned, what is the contention is that you have mentioned that Akhtari Begum since deceased.
Yes, my lord.
Was it in the original plaint?
My lord, it was not in the amended plaint of 2017. My lord, in 2017, the plaint was amended for the last time. Thereafter,
Was this in the last amended plaint?
Akhtari Begum has passed away in 2022 or 2022.
Very good. She passed away 22-23.
Yes, my lord.
Now subsequently, was it inserted?
She is not a party. My lord, I have sought that leave. I will only indicate that. In my
Which para you are referring to?
my lord,
It is
I am
proposed to.
kindly comes to
page 34, para
Roman 5, my Roman 5. My lord, this would be.
para 38.
But it does not change anything at all. Says
Para 34 of the plaint, where is it?
Para Roman 5, page 39 of the amended plaint that was served up. Roman 5, small Roman 5, paragraph.
My lord, we'll come to page 24 of the original plaint. Page 24. The last paragraph is
Paragraph 13.
The last paragraph is paragraph Roman 5. My lord, there, my lord will see the civil and criminal cases which was pending against the aforesaid mutualis was decreed in favor of the tenant, Mrs. Akhtari Begum. Is pending against the aforesaid mutualis and their men and agent. My lord, thereafter, this is in 2017. Akhtari Begum is not a party to the suit.
Which you are referring to? You are referring to.
my lord, paragraph 13, subparagraph Roman 5.
13 is
That on 3586.
that on 3586, my lord. Now, my lord, we'll come to the last sentence in that page. The last sentence, I will come to that as well. The last sentence in that page.
That is Mrs. Akhtari Begum is the lawful tenant.
She was the tenant, she has passed away. And that fact, she was not a party to the plaint. Because, my lord, this is a issue with regard to the waqaf. The waqaf was found by 3 persons and it was supposed to go to the respective legal male heirs.
Now,
Akhtari
what is
Begum
there?
not a
This
male
is,
heir.
this is the, I will not concern with that. This is a plaint.
Yes, ma'am.
Amended plaint as a last
Yes,
stood. Now, in this case, Mrs. Akhtari Begum is not followed by any within bracket words since deceased.
Yes, my lord. That was not there.
So-
I am trying to bring that in only because
So
she has
you
passed away.
you filed it here. What
Yes,
you
ma'am.
filed it here, you make your own amendment in the plaint.
No, my lord. I have indicated in paragraph 8, my lord.
So whatever he has filed it will be ignored. The question is,
Yes.
plaint is not amended.
Yes,
My lord, I
yes,
had sought for
He-
that.
rightly pointed.
He has done a wrong in the, he has done a wrong in the sense, not nothing was done in your back because plaint is not amended.
No, I have
This
not.
is a misguiding plaint.
My lord, now I am proposing to change that because she has after I have not amended. I have not done anything. I am only trying to propose this by
Propose this.
marking under green
Green.
underlining only because, my lord,
Where is your application? What are your prayers?
my lord will kindly come to my application. Let me place that, my lord.
Your application only substitution.
Yes, yes.
No, my lord. It is not substitution. It is not only substitution because I have sought for re-verification and reaffirmation. My lord had directed that I will file for substitution. But I
Mr.
am-
Dash,
Yes,
do
my-
first thing. One, you should to file an application for substitution.
Yes, my lord.
Then you have made other proposals.
Yes,
You
ma'am.
details what proposals, what to what extent plaint is to be amended. Make it in your application.
I
Then
have done that. My lord will come to
well, refer
paragraph
to that
6,
your para.
paragraph 6, my lord. My lord, from 5, my lord, the plaintiffs humbly submit page 8, my lord, paragraph 5. The plaintiffs humbly state that the consequential amendments due to the death of the original defendant number 4 be permitted. That apart, the last amended plaint therein, certain errors and omissions as also subsequent events and facts which the plaintiff proposes to correct and or incorporate by way of the amendment.
Yes.
My lord, I was coming. I will come. My lord will kindly, he'll allow me to
Formal
speak,
and
my lord.
fair.
I don't want to go behind anyone's back. I want to indicate. I have orders passed by the honorable court. I tried to carry out that amendment, but I have made certain mistakes. First change that I have done is, my lord, I will come before the plaint starts. My amended, my lord will kindly come to page 18, my lord.
18.
There,
Concise statement.
concise statement. In the concise statement, certain prayers were amended in the plaint pursuant to an order dated 2017 order passed by Justice
17th August.
Roman Sen. My lord, pursuant to that order, there was direction in terms of prayer A to H for amendment of the plaint.
Yes.
The plaint was amended, but by mistake, the concise statement was not, the proposed amendment did not show such changes in the concise statement. I am praying that
Please.
also be inducted.
So
That is
what he
one.
proposed here in this application is that the change of the substitution as well as some changes that he has made out.
Yes.
And all the
Formal and fair.
changes.
Please,
That he has marked in page 33 and page.
he has stated it, that is in the,
He has marked. But
Everywhere,
he is
my lord.
not without marking. He is doing this out of his own, without taking.
No, my
No, no,
lord,
no.
that is
These are
seeking
proposals.
permission.
No, no, no.
আরে এখানে মাস্টার সামনে আসতে বলো
Yes, just inform.
My lord, my learned friend's copy does not have that marking. Then his wrong copy has been
Yeah, wrong
stopped by my advocate. I
New
tender
copy,
my
fresh
apology. I tender my apology.
Give
I
a
did
fresh
not want
copy.
to do that. My copy is marked, my lord. That is why I was under the presumption. My lord, all I wanted to place. because
all
I
right,
don't-
give a fresh
I
copy
will
then.
do that. I will do that. I'll give my copy.
Adjourn to 16th October.
16 কি বার করছে?
My lord,
কি আছে
কোথায় গেল?
my lord, I'll give him a copy. I'll personally give him a copy.
Other matters tomorrow.
15 অক্টোবর কি আছে 16 অক্টোবর 16 অক্টোবর
16th. Obliged.
My lord, the next matter may be taken up on Friday instead of tomorrow, my lord.
16,
24, my lord.
but I have 24.
Yes,
But I have
Lordship
no
only
objections.
wanted to check whether
Who is
someone
in
was-
25?
Your Lordship,
Well, I'm there in
25,
25. I'm not objecting to this prayer.
I appear on behalf of the plaintiff. Your Lordship may kindly grant the adjournment and place it next week. Your Lordship.
24 on Friday, 25 on. When you like to have it?
Your Lordship, at your convenience next week, Monday, Wednesday.
ওটা চেক করে দিয়ে দাও। Take it.
Much obliged.
Yes.
Item number 18.
Whether I appear on behalf of petitioner
Latkaria Limited.
in 18,
Sir, you are for the plaintiff.
for the petitioner, late
GA2 is filed by whom?
my client.
My lord, only before my learned senior friend starts, my lord, we have preferred an appeal from the orders passed by this lordship, my lord. My lord, kindly, my lord, prefer adjournment because my lord, appeal will be coming up on, my lord. On 6th, my lord, it will be coming up, my lord.
There's no stay.
It will be coming up. That's the first it will come up.
There were two applications before my lord. One was my learned friend's application, which your lordship dismissed on the last occasion. And this is my client's application.
Against which order?
My lord, the order of, my lord, September 5. September 5. Where my lord had given liberty, my lord, to the parties, my lord, to use supplementary affidavit, my lord. Now, our contention is that, my lord, after 20 years, my lord.
My lord, your lordship had directed filing of a supplementary affidavit in order to give some
All right,
account
when there is an
of
appeal
the
pending,
20
let the
years.
matter be adjourned.
We have preferred an appeal. We have got a number, my lord. We will be serving them a copy itself today itself. Achha, copy.
In view of pendency of appeal,
Like, may I file the supplementary?
let the matter be adjourned to,
Next week, my lord.
no, when the appeal is pending, not before vacation. 30th November.
Grateful, my lord.
My lord, unless my learned friend's appeal is dismissed on the next.
Then it can be,
It can
liberty
come up,
to
my lord.
mention.
Yeah, my lord.
Liberty to mention. Lord.
Grateful, my lord. Back.
Supplementary affidavit filed by the petitioner be kept in record.
My-
You are plaintiff.
My lord.
Plaintiff be kept in record.
Item 19. Homeless Murli.
You have completed your argument, possibly.
Actually, Mala, I'll tell you, Lordship, on the last occasion, I wasn't here. Mr. Shengupta had addressed your Lordship, and your Lordship had kept it today for me to conclude the argument.
The point raised by Mr. Ghosh is related to rent.
My Lord. And my Lord, I had initially, when I was responding to Mr. Ghosh's arguments, I had indicated that his entire argument was confined to the fact that municipal tax, the liability to municipal tax forms a part of the rent. This was his argument. My Lord, while addressing that argument of Mr. Ghosh, I had shown your Lordship first some of the clauses of the original lease agreement between the plaintiff and the defendant number 1, which in no uncertain terms record the quantum of rent, which is admittedly 1400, well, below the threshold limit. Admittedly. Now, this admission is there in the cross-examination of the plaintiff's first witness, which gave rise to the application. Now, my lord, what the plaintiff contends is that municipal rates and taxes is another covenant in the lease deed, which creates an obligation on the part of the lessee to make payment of municipal rates and taxes. Well, that, in my respectful submission, remotely cannot form part of the rent. My lord, my respectful submission before your lordship is that in order to make municipal rates and taxes a part of the rent, there must be an intention in the contract between the landlord and tenant that this quantum of municipal rates and taxes, whether proportionate to the area under occupation of the tenant or otherwise, would form a part of the rent. Lord, here is a covenant which creates an obligation that you will pay municipal rates and taxes. So, Lord, the agreement has to be seen as a whole. This was an agreement which was executed 60 years back, by which the landlord, the owners rather, had granted a lease
to the first defendant to construct and let out. So the defendant number one has constructed the building and then let it out to us. We are the subtenants, recognized subtenant. Subtenancy created based on an authority given under the lease agreement itself. So my lord, here naturally, basically, it has the trappings of all the a sale, basically, the lease agreements, a long-term lease. It was, of course, I will not get into that part of the agreement that whether the termination could have been there. That will naturally, if it goes into the merits at the trial, it will be decided. Now, my lord, so far as confining myself to the liability to pay the municipal rates and taxes, my lord, if there is certain covenants which creates an obligation on the part of the tenant or the lessee to make payment of certain liabilities, municipal rates, repairs, or if something else happens that you have to take care of that as well. But that, in my respectful submission, cannot form a part of the rent.
That is exclusive of rent.
Exclusive of rent. Why? Those are variable components. A rent can never be variable in nature.
Maybe, but stipulated variation, such as 10% increase after 2 years.
Correct. Correct. So here is a case, or the clause in the rate said the municipal rates and taxes liability is entirely yours. So it's a liability under a contract. This cannot be equated with the rent component. When we come to this, we have found a judgment of this Honorable Court, which actually takes into consideration this issue. Allow me to place that judgment. I will deal with the judgment cited by Mr. Ghosh. And it will be my respectful submission before your lordship that none of the judgments have any remote application to the facts of this case. Eta tomra dekhechile EIH hotel ta? Kindly have a look at once this judgment in the case of EIH Hotel. A coordinate bench of this Honorable Court had passed a judgment. And my lord, here, before I place this judgment, my lord, only one factual submission. My lord, your lordship recalls the plaint. What is the plaint case? Plaint case is not that municipal rates and taxes form a part of the rent. Plaint case, if your lordship recalls, what is the paragraph in the plaint? 6. That plaint paragraph specifically says that this is the quantum of rent. Paragraph of the plaint. Well, I'll just read out for your lordship's consideration. Paragraph 3, which would be a part of volume 1 of the compilations we made over to your lordship. If my lord kindly takes para 3, page 9 of the compilation. Your lordship has that. Para 3. By a registered deed of lease of 1965, such and such granted a lease of the premises, such and such to Octavius, which is the first defendant, for a period of 99 years, commencing from 1st January 1962, yielding up thereof a monthly rent, 1400, to be increased by 100 on the expiry of every succeeding 9 years.
The rent is 1400.
Yes. And now, my your lordship will see 100 rupees on expiry of every succeeding 9 years. My lord, identical, in cross-examination, witness says the same thing. But no case made out. Now, my lord, from the bar, when we've taken the point of rent, my lord, this is the submission from the bar. This is not the case by which the plaintiff has attracted the jurisdiction of this court. Well, what we are on before your lordship is that would this court have the jurisdiction to entertain the suit? The reason being the quantum of rent. One of the reasons for which we say that this court doesn't have the jurisdiction is pecuniary threshold. And it takes it away from the jurisdiction of this honorable. And your lordship will see.
Just a minute. Let me go through it.
My lordship, lecture. That one.
Yes, these judgment discussed in details.
Is your lordship looking at the judgment, EIH Hotel judgment? I saw it.
Yes. Now come to a point.
Yes. So, my lord, if your lordship will kindly take the EIH.
So, Mr. You are once again coming here.
Should I leave, my lord?
Which matter? This matter.
Defendant number 1.
Yes, he is fighting a number of cases.
Oh, yes, yes.
On behalf of this Octavius T.
Yes. And my lord, that is our strength. Octavius T. and Mr. Mitra. My lord, if your lordship will kindly see. My lord, this is precisely what has been considered. If your lordship will kindly take once para 22.
Para 22 of?
Of this judgment. EIH Hotel. My lord, after Gujarati Education Society was considered, the definition of rent in its wider sense not only includes the basic rent, but also the other amount payable by the tenant in lieu of amenities and facilities attached to the tenancy, and may further include the maintenance, service charges, and municipal tax and commercial surcharge, which is a statutory obligation. Any amount which is variable in nature and depends upon certain contingencies cannot be characterized as rent. There is no ambiguity in case the landlord intends to recover the other amount along with the basic rent, treating all constituents within the wide definition of rent. But the question still begging an answer, whether such constituents than the basic rent can be included within the definition of rent within the statute provides, when the statute provides a protection up to certain limits. Section 3 of the Act is newly inserted provision which was absent in the predecessor Act. The Act of 1956 did not contain any ceiling limit that the premises fetching a rent up to certain limit shall be kept outside the purview of the Act. Section 3 kept certain premises let out for residential or non-residential to the exempted from the operation of the said Act. If it carries rent more than 6,500 as monthly rent in the area of the limits of the Kolkata Municipal Corporation and Howrah Municipal Corporation, such and such areas include such and such. Now, the explanation appended thereto explicits that where the premises is let out partly or residentially or for non-residential purposes, it would be governed by the provisions applicable to non-residential. The Rent Restriction Act is a welfare legislation protecting the tenant from unfair eviction by the unscrupulous landlord. Though Section 6 of the entitles the landlord to evict the tenant from the tenanted portion for any portion envisaged, 7 provides protection. Now, my lord, kindly come to paragraph 26. Normally, the exemption provision in the statute is to be construed strictly on the touchstone of legislative intention. Any interpretation which gives rise to anomaly or absurdity should be avoided. The aforesaid principles are not free from exception, which may be seen in case of a taxing statute. The exemption clause is really in the nature of an exception, and true interpretation should be given after reading the different provisions of the said Act and predominant object for which the Act is enacted. The true and correct meaning of the rent under Section 3 of the Act can be attributable to all payments required by the tenant to be made to the landlord in lieu of use, enjoyment, and occupation of, and further includes the facilities and amenities provided by the landlord at his cost. any payment which is unconnected with the facilities and amenities for which the landlord has to bear, though recoverable as a rent, cannot be brought within the definition of rent for the purpose of 3 of the Act. Now, my lord, it refers to a division bench judgment in team consultants. Then it says that the position emerged inescapable that the corporation tax and municipal surcharge, though falls within the obligation of the tenant under Section 5 thereof, cannot constitute rent for the purpose of Section 3. However, the position would be different when the tenant seeks protection under eviction under Section 7. Now, my lord, applying the principles of this judgment to the facts of our case, if I may just trouble your lordship with 2 paragraphs of the plaint. This is the plaint before your lordship. Lord, there cannot be a third case today made out. So you have filed a suit and you seek recovery of possession based on the averments made in the plaint. So, my lord, kindly have a look at paragraph 3 of the plaint.
1400.
Yes. And my lord, it continues and it refers to the lease deed. So, my lord, I also have the I also refer to the lease deed because this clause refers to the lease deed. This paragraph in the plaint refers to the lease deed. Now, if your lordship will kindly if I may once again trouble your lordship with one clause in the lease deed. The indenture of lease starts at page 39. Well, what the plaintiff refers to is at page 40. Your lordship will see there are clauses given numerical 1, 2, 3, 4. At page 40, this is how the parties envisaged the rent to be paid in respect of the subject property. So this is the rent obligation. Page 40, page 39, the lease deed starts of the compilation. Is your lordship
compilation?
Yes, my lord. Now the same, your lordship is looking at the plaint.
Original plaint.
Now, my lord, kindly take page 39 where the lease deed is a part of this compilation.
So your point is that para 1 of the lease deed.
Yes, my lord. At internal page 2, running page 40.
Rather, para 2(1), Roman 1. Monthly rent shall be to pay monthly
Reserved,
rent.
correct.
And separately existing municipal taxes.
Correct.
That's why
Now, my lord,
rents are separated.
Yes, my lord, if your lordship will kindly turn 2 pages before that at page 40.
Yes, that is there.
Internal page 2, running page 40.
Monthly rents as follows.
Correct. So parties envisaged in the contract that this would be the rent. And this is what the plaintiff avers in paragraph 3 of the plaint. So there cannot be any dispute to that. So this is how you have attracted the jurisdiction of the court, and you have said that this is my rent. Now if your lordship will kindly see that page your lordship was looking at, page 41. These are the obligations of the lessee. Various obligations are there. So one of the obligation under the lease deed is,
you are referring to?
My lord, clause 2, running page 41. Is your lordship looking at the compilation?
No, I'm
very
looking
well.
at the plaint.
Sorry. If your lordship will take internal page 3 of the lease deed. Internal page 3 of the lease deed.
Para 2, sub para 1 to Roman 1.
Correct. Roman 1 says monthly rent. Then Roman 2, to pay all existing and future municipal rates and assessment imposed or charged upon in respect of the demised premises or any part thereof, such and such, such and such, such and such. Then, my lord, kindly take Roman 3 also. Within a period of 15 years from the date of these present, at its own cost to erect and complete at least a 4-storied building in the substantial and workman-like manner. Then it continues to keep the exterior interior. So, Malad, these are some of the obligation like the municipal rates and taxes, there are other obligations. Now, my lord, independent of the rent. So, my lord, hypothetically, if I had not paid the municipal rates and taxes, I would be in breach. So you could have sued me in an independent suit, saying that you have failed to pay the municipal rates and taxes, which there is a demand from the Kolkata Municipal Corporation. I'll go to the averments in the plaint. This is one of the case made out in the plaint itself. To the amount of X, you are liable to pay this. Otherwise, the property would be exposed to attachment under the Kolkata Municipal Corporation Act. Pay it. Why? It's your contractual obligation. So he seeks enforcement of clause Roman II. You're in breach, pay. So now what has been sought to be contended before your lordship is that this forms a part of the rent. So my endeavor before your lordship is to say that the rent was all along agreed by the parties to be separate. And there is an independent separate obligation to make payment of the municipal rates and taxes. Cannot be equated together, or the concept of proportionate share of municipal taxes being added to the rent and it becomes a part of the rent. Even that theory will not apply in the facts of this case. Because here is a lessee who was given the authority of the entire property to construct and then sublet, and the entire obligation to make payment of the municipal rates and taxes in respect of the entire building was that of the lessee. So now, if your lordship will come back to some of the averments in the plaint, he says, he makes out that case that I am in breach. I have, if your lordship will see, the municipal rates and taxes I have failed, he says. But if paragraph 50, page 15 of the plaint, Roman II, taito. So Roman II at page 15, failed and neglected to pay rates and taxes. So that's my breach. So this is independent of the quantum of rent.
So your submission is that rent doesn't include municipal rates and taxes in this specific case.
In this case, it depends on the facts of each case.
Agreement between the parties.
Correct. It cannot be a blanket proposition that in every tenancy, municipal rates and taxes always forms a part of the rent. It doesn't, at least not in this case. Why? Because there is a contract to the contrary. It is my obligation, the first defendant's obligation to pay the entirety of the municipal rates and taxes. So that never forms a part of the rent. That's an independent obligation. Now, this judgment, it is Supreme Court. This judgment of our court was appealed against before the Honorable Supreme Court. And my lord, if your lordship will kindly take. This is the Supreme Court judgment of what I showed your lordship, the coordinate bid judgment of Justice Tandon. This is 2022 SCC Online Supreme Court 947. This is what happened. But in EIH, what had happened is the plaint was rejected based on the fact that the court lacked pecuniary jurisdiction. It was transferred to the court. Now, this was upheld by the Supreme Court. If your lordship will kindly take the trouble of coming to paragraph 19 onwards. My lord, the answer is at para 20.
Yes, I am reading para 20.
My lord.
Yes, I will read it.
My lord, the middle portion of para 20. However, it is required to be noted that the tenancy agreement does not provide that the parties have agreed that the rent would be inclusive of municipal taxes payable, and that as and when such taxes are enhanced, rent would be proportionately raised. So that was even a touch and go case, if I may say. But our case is absolutely clear. There was a unit over there. Here is the entire building. So entire liability of taxes lessees. So how remotely would it form a part of the rent? Now, my lord, your lordship will see eventually what Supreme Court holds. Taking into consideration subsection 8 of section 5 of the Premises Tenancy Act, which casts an obligation on the part of the tenant to make payment of the municipal rates and taxes based on the amendment to the Premises Tenancy Act, and after following, my lord, Calcutta Gujarati Education Society, my lord, Popat Kotecha is also considered. My lord, kindly come to para 28. Now, so far as the reliance being
That
placed,
distinction was made.
correct.
Popat
Absolutely.
Kotecha property,
Yes.
there was agreement, rent will be part of rent.
Yes. Well,
Tax will be part of rent.
Popat Kotecha, what happened? They said that I am entitled to enhancement of rent. So by enhancing the rate, the jurisdiction of the courts was attracted. So that's what's been considered in para 28. Now, so far as reliance being placed upon section 18 of the Act of 1997 and the submission that the section 18 of the Act, the rent shall be automatically increased by revision of 5% every 3 years. And therefore, by giving the increase by revision of 5% every 3 years, the rent payable would be more than rupees such 10,000 per month is concerned. The aforesaid contention has no substance. Section 18 of the Act shall be applicable in a case where the fair rent is determined and fixed by the controller under 17. That is not the case here. Therefore, section 18 is not applicable. So this is the manner in which the jurisdiction of the court was sought to be attracted. In view of the discussions, reasons above, the monthly rent due and payable would be 10,000 per month, which cannot be said to be more than 10,000. High Court has rightly observed that the held 97 Act shall be applicable, and therefore the civil suit filed invoking section 106 impliedly barred. Therefore, the High Court has rightly rejected the plaint, such and such. Now, my lord, I'll come to the judgments Mr. Ghosh has relied.
Have you filed any compilation of judgments?
Who, me?
Huh?
We'll file it.
Because these are loose judgments. You file better.
Yes, yeah, we certainly make it a part. My lord, allow me to deal with just, I'll not take
judgment.
What is that? My lord, kindly take the judgment Mr. Ghosh had relied upon. This is a judgment in 1996 7 SCC. This is my learned friend's compilation. 96 7 SCC 298. Josh সাহেবকে compilation written note দিন। ঠিক আছে। তোমরা দিয়েছো? তো বলো না, দেখে দাও, বলে দাও তোমারটা কোনটা। It's stitched.
Yes, together.
But tell him that. এখানে আছে তো। It's a part of this, yeah.
Municipal Corporation versus City of Ahmedabad.
Correct, absolutely. কোথায় গেল? এটা তো গুজরাটটা। My lordship kindly gives me a moment. 96.
This is Gujarat.
My lord, kindly. Canara Bank, Municipal Corporation. My lord, here your lordship will see what was being considered it's a short judgment, my lord, kindly see. The question before the full bench of the Gujarat High Court was whether municipal tax paid directly by the tenant to the corporation can be included in the annual letting value as defined under section 21A of the Bombay Provincial Municipal Corporation Act 1949 for the purpose of computing gross rateable value of the rented premises for the purpose of levying property tax by the corporation under the Act. The appellant's contention was that such directly paid tax by the tenant could not be taken into consideration to swell the annual letting value for the purpose of property tax. Corporation contended to the contrary. Full bench High Court rejected the contention of the appellant and accept the contention of the corporation. We have been taken through the judgment of the High Court. We see no infirmity in the same. So, my lord, when it says it doesn't form any infirmity in the same, so whose contention, my lord, your lordship will kindly see? Contention of the corporation. Accepted the corporation of the contention, and the contention of the corporation is that the corporation contended to the contrary, which is directly paid tax by the tenant could be taken into consideration for the letting out value. How would it remotely apply to the facts of our case? Well, what we are, well, what
That
is
means you want to make a distinction between
yes,
annual letting value and actual rent
rent payable by a tenant
under Premises Tenancy
correct,
Act.
and there is an annual letting out value assessed for the purpose of assessment of property tax on a building.
That is one thing,
Completely different
and
thing.
rental legislations are different thing.
Absolutely. Now, my lord, as your lordship is aware, but now we have a unitary assessment concept. So, my lord, the unitary assessment concept is on a different footing altogether. Previously, there were three methods prescribed: market, letting out value. So the actual rent were taken into consideration. Market letting out value were taken. Well, my lord, in my respectful submission, this proposition has no manner of application in the facts of our case, which is confined to what was the rent payable in the facts of this case. And my lord, there is an admission in para 3 and in the cross-examination of the plaintiff's first witness. Now, your lordship will kindly come to the second judgment that Mr. Ghosh relied upon, which is the Gujarat judgment which went up in appeal before the Supreme Court. The 92 is the Gujarat judgment. My lord, your lordship has just read the Supreme Court judgment.
96.
Yes, that is the full bench judgment of the Gujarat High Court that Mr. Ghosh had relied upon. Gujarat High Court ta kothay gelo?
92 SEC online.
Yes. তাই না? The Gujarat High Court judgment, your lordship will see 1992 SEC online Gujarat.
Now, what other judgment?
My lord, kindly give me a moment, my lord. Gujarat High Court ta kothay gelo? 92 Calcutta. Kindly give me a moment.
You take it from me.
No, my lord, I found it. This was the first judgment. This is the same judgment which went up. Municipal Corporation of the City of Ahmedabad versus Canara Bank. My lord, since the Supreme Court has said what it did, so my lord, the facts of this case is the same. So my lord, even here, if your lordship will see, the distinguishing feature your lordship will be able to make out what was under consideration is from paragraph 39 of this report. Para 39 and para 47. This will make it abundantly clear that this judgment would not have any application in the facts of our case. This is not the issue at all. Para 47 and your lordship see, para 39 and 47. Flag code Thus, Gujarat full bench was considering this issue annual letting out value. Assessment of property tax by the corporation.
Burden borne by him becomes component of rent. That is the observation.
When? Your lordship has seen that Supreme Court judgment, which went up from our court?
Depends on the agreement.
Correct.
Yes.
Now, my lord, my learned friend has also relied upon a division bench of our High Court to 23 SCC online Calcutta 899. Well, the first para itself indicates of this judgment 2023 SCC online Calcutta 899. First paragraph. An interesting point is, does your lordship have this judgment? Interesting point is raised in the instant appeal relating to the definition of rent, which has not been defined in the Act itself. The undisputed facts unfurled from the record is that a suit for recovery of possession under the Transfer Property Act was filed after the expiry of the period provided for in the notice under 106. It is also not in dispute at the point of time tenancy was protected by the Premises Tenancy Act 56, as it does not make any distinction on the score of quantum of rent, but after the promulgation of the Premises Tenancy Act, tenancy which fetches the rent above the cap mentioned therein may not come within the periphery of the Premises Tenancy Act. Then Section 3 of the 97 Act contains exemption clause. Such a distinction can be seen then that 10,000 threshold limit is being considered. Now your lordship will see. Kindly come to my lord, paragraph 5. Para 5, my lord. considerable debate on the issue of rent. The only point which is raised in the instant appeal is what definition can be assigned to the word rent, which is admittedly not defined in the Act of 97. There has been a considerable debate on the definition of the word rent, and the various judicial pronouncements have been made defining the rent. Now, my lord, your lordship will kindly take into consideration paragraph 8 and 9. EIH hotel has been taken into consideration. My lord, which we just showed before your lordship, the Supreme Court, which went from the coordinate bench of this honorable court. So EIH hotel is taken into consideration. Provisions of the Act has been taken into consideration. My lord, kindly take paragraph 10, starting at paragraph 10.
Proposition of law.
Yes, the proposition of law as enunciated in the aforesaid report exposes that the property tax cannot ipso facto come within the purview of the rent, but this is the proposition, but depends upon the intentions and the conduct of the parties in relation thereto. It can be safely said that there is no uniform principle that the property tax shall be outside the purview of the rent, but it depends on the facts of each case, which can be conceptualized from the examples quoted in the aforesaid passage. It has been held that if the parties have agreed that the amount shall include tax, then in that event, tax component will become a part of the rent. There is no scintilla of doubt in our mind that every component in respect of enjoyment of premises payable, then continue. So one of the result is all judgment Supreme Court is what the parties intended. And my lord, in the facts of this case, my lord, the intention is apparent, not only from the lease deed of 1962, but from paragraph 3 of the plaint. Well, I rest my case. My lord, these are my respectful submissions. And my lord, if I may just, lordship will pardon me for repeating this, my lord, kindly, my lord, also make a note of the cross-examination of the plaintiff's witness, where he unequivocally admits that this is the rent.
Would you file any notes of argument?
Yes, we'll file it. Kindly give us, my lord, a week's time.
Next day, you file notes of argument.
My lord, may Mr. Ghosh have 10 minutes to distinguish the two judgments that have been relied upon by my learned friend. On any day convenient,
Ghosh?
not more than 10 minutes.
After vacation, Mr. Bosch.
Very well. কোনটা আছে বলো? বলো, বলো, বলো।
My lord, not more than 10 minutes, if it be my lord's pleasure to keep it this side of the vacation.
Problem is that after vacation, if the vacation intervenes, I will forget everything. Will that be good for you?
My lord, as my lord pleases.
Then, my lord, when give me 5 minutes and then the rest 10 to Mr. Ghosh. So then, we can, my lord, we come back after the vacation. We can
Yes, because
recapitulate.
I may not get time to, this will not be a definitely smaller order.
No, definitely, my lord. Then, my lord, I am sure my learned friend will not
17th November.
disagree if I make seek an indulgence from your lordship to treat, since your lordship has substantially heard the matter, kindly treat the matter as part heard.
Hard in part. That is the first word.
Hard in part. Great.
17th November.
Great.
Deeply obliged.
Hard, Mr. Bosch. Hard in part, adjourned to 17th November.
Item 20.
But I appear for the caveators, my lord. I had to reply, I was continuing with the reply, my lord.
Yes. You are the plaintiff.
Well, may I continue with the, because we have already placed the grandfather's will and how it was attested, that was already placed on the last. Well, let me continue with the will of the Gaurlal Mitra, because why we say that probably this will is not a genuine one and the suspicious circumstances surrounding the will. For that, my lord, may I place the will, my lord, the original?
Yes. Mr. Ghosh, I have not heard you or I have
Yes.
heard.
Yes, your lordship has heard me. I'm the propounder, and thereafter my learned friend is giving the reply. I'll get a chance of reply once.
Declare better both of you file a notes of argument.
Let them finish the.
All right,
their
let him
argument.
finish.
I don't know.
Yes.
Definitely.
My lord, kindly seize, my lord. This was, my lord, that point was we have already submitted that this will was registered on 27th February 2020.
Here is the problem.
That was there, my lord. Now this starts with, this is the last will and testament of Sri Gaurlal Mitra, son of late Adhar Kumar Mitra, residing at premises number 5/1/A Rajvallabh Street, Kolkata 3. Now, my lord, the most important part, the third paragraph. I hereby appoint my younger son, Sri Kamal Kumar Mitra, at present living with me at my above dwelling house, being the said premises number 5/1/A Rajvallabh Street. And that's why the younger son came into the picture. My lord, the first page, where the will starts, third paragraph, where the executor is named, my lord, the younger son. I am now fourth paragraph. I am now 80 years of age. My wife had more than 8 years, died more than 8 years ago. I have two sons, Sri Shyamol Mitra, that is the elder son, and Sri Kamal Kumar Mitra, and three daughters, namely Chandra Dash, Kumkum Bishash, and Jhum Shen. And my lord, here the younger daughter has was present before the court and adduced the evidence. Now, my lord, kindly spills over to the next page, my lord. This properties have been derived, my lord. Nothing has been spoken about how the propounder has derived title of these properties. Nothing has been spelled over. No mention of that, my lord. Now, my lord, kindly spills over to the third page of the will. Now, directly comes to the, my lord, for preparation of the will, it is very necessary that the propounder or the testator should mention from where he gets the title of the property. That is nowhere mentioned in the will, my lord. And my lord, kindly comes to page 3 of the will, my lord, the last paragraph. This is most important, and this is the only reasoning that has been put forward why the elder son was not given an inch of the property, my lord, in the testator's will. I brought up my elder son, Sri Shyamol Kumar Mitra, giving him the best possible education and provided him all training and discipline necessary for his work and present station in life as a branch manager. My lord, kindly sees the language, how this has been written, of a nationalized bank, because this is very important, because I am harping on the point that I will submit, my lord. The testator probably did not have a sound knowledge of English, and kindly sees the language that has been mentioned in the will. My said elder son, Sri Shyamol Kumar Mitra, has not conducted himself properly with me and has left me over several years to lived with this family at 57 such and such. He now resides at 518 Robindra Sharoni, a different address that is testator is mentioning. He, however, has failed and neglected to look after and educate his son and daughter properly in the best of their interest. So that is one of the reasons why he is secluded from the will, why he is not named as one of the executors, or he is not given a benefit under the will. This is one of the reasons. Further, the second reason that the testator mentions, my lord, further, he never cared to take any opinion,
Take my opinion.
and advice at any point of time about them. At times, I felt insulted by his rough and rude behavior with me. He led an extravagant life. My said son, Sri Shamul Kumar Mitro, acted against my wishes and against the traditions of my family, and further, without considering the impropriety with regard to the duties and responsibilities of himself and his son and daughter as Shebayat of Sri Sri Radha Madan Mohan Jiu and Sri Mahadeva, the latter being my own family deity. Recently, he prompted his. Well, kindly sees there is no pause in the sentence. It is being continued, no reasons whatsoever. He prompted his daughter to marry a man professing an altogether different faith. And he lost all my sympathies for him and my said granddaughter. For this reason, amongst others, I totally disinherit my said son, Sri Shamol Kumar Mitro, and his wife, son and daughter, and his heirs, executors, and legal representatives from my aforesaid properties and from each one of them. My lord, how this is being described in the will? Probably the basic two reasons that the testator was trying to say while disinheriting the eldest son, my lord. First one being he is not following the family duty that his father supposedly thought that my eldest son should do, that usually a normal father thinks, my lord. And the second reason being, my lord, that he has led an extravagant life and he has brought up his children, that is the testator's granddaughters and grandsons, in a different manner. And in the meantime, while raising the granddaughter, my lord, she has married to a different religion. That is the basic reason why this has been, he has been disinherited from the property. Now, my lord, kindly sees the further reasoning. My said son, Sri Shamul Kumar Mitro, will have no right, title, or interest in any of my aforesaid properties and be debarred from worshipping our family deities. Sri Sri Radha Madan Mohan Jiu and such, Sri Mahadeva as a Shebayat forever, and his wife, his son and his daughter, and any other heir or legal representative will be similarly disentitled to act as such Shebayat or Shebayats of my said family deities as aforesaid. The said deity Sri Sri Radha Madan Mohan Jiu is located at such and such place. So basic reason is given, my lord. Now on the next page, my lord, on page 5, my lord, he says how this rents will be collected. And on the second paragraph, how he gives a benefit to the daughters, but in 2001, the benefits that has been given to the daughters is actually not a benefit. Kindly sees this. This is the second paragraph. The rental income, how the property will realize, that has been first described in the first paragraph. Out of the rental proceeds, how this will be distributed, he has defined that. Out of the said rental income of the aforesaid properties, I give, devise, and bequeath the following annuities. This is the Roman 1, my lord. This is the important. This rupees 300, each per month to my 3 daughters, Chandradash, Kumkum Bishwash, and Jhumjhum Sen, till their respective natural lives. Apart from rupees 300, nothing has been given. Nothing, absolutely nothing. Then, my lord, other expenses are given. My lord, this is the basic reason where the other legal heirs are completely disinherited from the will. There was Nothing given apart from the younger son being appointed as an executor. Now kindly comes to my lord, this is how the will, my lord, has been written and it has been signed, my lord, by the testator. And kindly comes to the last page, my lord, page 10. My lord, there is nothing which would show, my lord, because one of the attesting witness was Mr. Ashok Ghosh, who was also an advocate, my lord. Nothing would show that this will was read over to him. Nothing. Usually we have that this will have been read over and it has been explained. Nothing in the statement, my lord. Usually it happens to be in the last page, my lord. Nothing has been written. Now, my lord, kindly sees on the English language, I'll straight away take my lord to the evidence. Also, we have taken, my lord, the inspection of the original will, my lord. Some discrepancies, my lord, we have noticed. My lord, kindly comes to the page 1.
Evidence to the
না এখন একটু উইলটা একটু জজ সাহেবকে দিন।
Yes, it is here.
My lord, kindly takes the will once. Because we have taken inspection, we have seen certain discrepancies. My lord, kindly sees page 1.
Yes.
My lord, kindly sees the testator's signature. It is vertically done and it is touching one of the letters just above me. Kindly sees that. And my lord, what we have seen, the margin is different from each page. My lord, here the margin is somehow the distance of the script is like one figure. They kindly sees this. If my lord kindly puts 2 finger, my lord, that will be the distance. Kindly comes to the second page. This is the signature variance. It is totally different from the first page. My lord, the gapping on the first, kindly sees the first page from where the signature was put. That gap and the signature on the second page, my lord, the gapping is different. Most probably, if I put 4 fingers, that will be the gap. This is the abnormality.
Gap in?
Gap kindly sees where the signature is ending. And it is starting from where? Kindly sees the
Touching the type letters.
Yes, touching the type letters and the type letters is started from the margin. My lord, kindly sees the dissimilarity.
Where this point is taken by you in the written statement, in affidavit?
No, we are at that point of time that was not taken probably. We have taken inspection letter, my lord.
But evidence also as far as stand corrected, that signature is forged. No, not the case hasn't been made of.
My lord, what I was trying to place before your lordship, why this is, I'm bringing it before your lordship. This is one of my points, that probably the signature were there and then this typing must have been done.
On blank paper.
Blank papers.
That point have you taken in the written statement?
Probably we have taken the inspection, my lord, not in the
written statement.
Not in the written statement.
Then how can you argue that?
My lord, it is usually the affidavit in support of caveat, my lord. We have taken the points of.
You might have amended your written statement subsequently.
My lord,
Any
this is,
subsequent point have come to your notice.
my lord, this is the point of law. We can come before your lordship and argued this point at any point of time on the basis of suspicious circumstances. We can do that.
Suspicious circumstance is a point of law, but certain facts constituting suspicious circumstances are nevertheless factual issues. How the suspicious circumstances is constituted, these are often facts. These are factual aspects. On these factual aspects, you rest your legal point, your legal argument. Anyway, go on.
My lord, these are the discrepancies that my lord kindly sees in all the pages. My lord just spills over to all the pages, especially
Touching the type letters.
touching the type letters. I would kindly, my lord, keeps a note of this page number. Especially, I am harping on page number 1, 2, and 3.
Some pages
Different.
it is there.
Yes, some pages it is there, my lord. And kindly sees page number 4, 5, and 6.
First point is there is no strong reason for disinheriting or inheriting or depriving the elder son and his family.
And also the daughters. My lord, rupees
But what
300.
is
My lord, that is
bigger
one
amount
of
to
the
the
points.
daughters?
Yes.
Number 3 is that genesis of title is not discussed at all. He has not traced how he got the title.
Yes.
That is another point suggesting suspicious circumstance.
Yes.
Signature is another point for suggesting suspicious circumstance.
Yes.
Anything more?
And my lord kindly sees, my lord, why I take out this point.
Another point is date.
My lord, kindly once come to page number 6 of the will. Sees the sentence starting from the above and kindly compares it with the other pages. Sees the margin gap.
That may be, but the point which you should argue is that the will dates 28 February, whereas it was registered on March
27 February, that, my lord, we have already argued on the last occasion, my lord. Judgment will definitely, my lord, come out with, my lord. My lord kindly comes to my affidavit in support of KVA. My lord, as my lord was mentioning, whether I have taken up this point, my lord. My lord kindly sees paragraph 20.
Signature was undue.
There was no indication of Gaurlal Mitra till his death about execution of will dated such and such, and the said will has been procured by fraud and undue influence.
Signature by undue influence.
That has been taken, my lord.
But not that it was taken a blank paper.
That probably, my lord, after inspection we have, but in a general point, my lord, this has been covered, my lord. We have taken that. And kindly sees paragraph 17. Gaurlal Mitra since has acquired no transferable right, title, and interest in respect of estate of late Adhar Kumar Mitra, and will of it at all executed by him is of no consequence or effect on the estate of late Adhar Kumar Mitra, and Gaurlal Mitra's will, if any, should remain confined to the extent of his self-acquired properties. I deny that the Gaurlal Mitra executed any will during his lifetime. And will has been applied for being probated or obtained by undue influence, suppression of fact, and by coercion. So the whole will I have challenged, my lord. So this, and execution itself, my lord. So this point automatically comes under that. Now, my lord, kindly comes to the evidence ones. My lord, I will straight away
Evidence.
Take your lordship.
Deposition of
Kamal Kumar Mitra, the executor. Language to
which part you referring to?
My lord, kindly comes to question number 216. My lord, he is probably referring exhibit D.
Do you find from any portion?
Do you find probably exhibit D is the registered will of Gaurlal Mitra, 28th February 2021. That is exhibit D, my lord. Do you find from any portion of the exhibit D that the contents of the same were read over and explained to your father? I do not know if it was read over and explained to him, but this much I know that it was his nature not to affix his signature until he understood the purport of a document. This is clearly that it was not read, even the executor cannot say. Executor, in fact, cannot say. He could not say that he was present. Now comes to the next question, 217. I put it to you that your father was not in a position to understand English language and could not comprehend the contents of the will. I disagree with the suggestion. He might not have been very sound in English language, but he was clear in his conscience, and unless he understood and was convinced, he never signed the document. Question number 218. If I put it to you that from the time of preparation of the draft will till execution of the will, apart from signing his name, the only other time he had written in English the word approved, because my lord, in the draft will, somewhere he has written a word approved under his short signature. That word approved is also wrong. That I will come to your lordship. There is a misspelling, which he had also misspelled, which means that he was not conversant or not comfortable in writing and speaking in English. What do you say to that? My lord, before I proceed further, my lord, kindly sees exhibit J. That is the draft will according to the executor that was given to the advocate for proceeding further of taking probate and preparation of the will. Exhibit J is the draft will and exhibit K is the signature by which he say approved, and there is a signature. Exhibit J, this kindly sees this is the draft will. Probably question number 218, he is mentioning that. Kindly
How
sees
this
the
can be
bottom.
exhibit J? That must be a draft will.
Exhibit J is the draft will.
No,
They have disclosed. My learned friend has disclosed.
how this can be? This is subpoena.
Exhibit.
That is not J.
It's a tight suit CS90J.
What is CS90?
CS90 is the partition suit, my lord.
Oh, both are hard together.
Yes, my lord. Probably after this, my lord have to withhold the judgment. We have to complete that, my lord, and then.
First TS, then CS.
Yes.
तो पाओगे तो come next day. Let it be worked out. Other weaknesses are waiting.
Very well, my lord. My lord, sometime after vacation, my lord.
Hard in part. Let the matter appear in the list on 7 December.
7 December.
December. And then your lordship will direct them to give notes also. We'll bring our notes.
Notes of argument, maybe parties are at liberty to file notes of argument.
Very good. My lord, should we come up after the completion of partition suit? Should we come up with both the notes or for
No, this much.
this
Because two jurisdictions cannot run simultaneously. Yes.
My lord, in item number 21, I am for the plaintiff. I have filed application for amendment of plain.
We were seeking an extension of time to file our opposition.
The learned counsel for the plaintiff
Witness name.
craves leave to file. The learned counsel for the plaintiff filed.
Well, he's for the.
I am for the plaintiff.
Yes, plaintiff filed application for amendment of plaint being GF4 of 23. The learned counsel for the defendant, Mr. Ghosh, craves leave to file craves leave extension of time to file affidavit in opposition. Let the same is allowed. Affidavit in opposition is to be filed within 2 weeks. Affidavit in reply, semicolon the affidavit in reply within 2 weeks thereafter.
My lord, that 2 weeks will be in vacation.
Made be on
Including vacation, so what?
Made be on the reopening day, 16th.
Let the matter appear in the list.
No, I'm saying, my lord, the opposition, then let it be on the reopening day.
Within 1 week after reopening.
Very
Let the matter appear in the list on 12th December.
great. So 2 weeks and
1 week after vacation,
yes.
after reopening.
And then 1 week for them to, or 2 weeks for them to file.
2 weeks for affidavit in opposition, 1 week for affidavit in reply after reopening.
But I was praying that opposition can be given on the reopening day, also 16th, and then my learned friend, and then it'll be on the 12th. Then in case of some corrections, actually there's
Affidavit,
one
all right, affidavit in opposition shall be filed within
date.
22nd November.
Great.
Affidavit in reply, if any, within the returnable date. Let the matter appear in the list on 12th December.
Great.
Item 22.
My lord, I am for the plaintiff. The suit is set ex parte against the defendant. May I file my judge's brief of documents, my lord?
Where is the affidavit?
My lord?
Have you filed evidence on affidavit?
No, my lord.
Where is your
My lord, my witness couldn't come today. My lord, she will kindly fix it any day after the vacation. But may I file an affidavit of evidence because it's set ex parte? Affidavit of evidence.
No, you have to produce the.
I have to produce the witness. May I file an affidavit of evidence on the next day? The examination in chief is only.
Prayer of the learned counsel for the plaintiff. Examination of witness is postponed to.
Your lordship. May I file the judge's brief of document? Let that be kept on the record.
18th October.
Your lordship, I was appearing on behalf of the defendant. I know there's been an order to that effect that it's been decided as an undefended suit. I was wondering, I know I have no right of audience here, but I would like to make a small prayer, your lordship. Basically, my clients, they have had a lot of management change. So we weren't able to get sufficient information from them. If your lordship gives us liberty, we'll file an application for.
That's that's open to you. You file application, whether that will be
Third
tenable or
time
not.
they came forward, makes the same prayer today.
All right.
Let them come. If they come up, I'll defend it. But can it be after the vacation, my lord? Instead of 18th of October, can it be on the reopening?
All right. 18th of October in place of 30th November.
Obliged.
I'm grateful.
Obliged.